The UK would suffer a much bigger economic hit from a no-deal Brexit than the rest of the EU, which mirrors the government's own exit analysis. But in reply, you referred to a Bank of England analysis which showed that, and I quote, according to the transcript, it would in a material way be worse for the EU side. Could you just tell us which economic study were you referring to of the Bank of England?
I'm very happy to send you a copy of it, and it was in relation to material aspects that I think it had pointed to the disproportionate impact it might have on the EU side. And I think, from memory, it was in relation to financial services, but I'm very happy to send the committee details of that.
Was it particularly about derivatives, that study?
I would need to go and check again.
Right. Because I understand there had been some clarification by, I don't know whether it was the DexEU press office that it referred to derivatives. It's just, I'm just trying to make sure that when you said it could be worse for the EU, if it was in fact only referring to one small area, the government's own exit analysis and the IMF report that's just come out makes it very clear that the hit is much bigger for the UK than for the rest of the EU. Is that your understanding of what those two bits of work have shown?
Mr. Chairman, I was making the broader point that there have been all sorts of various different analysis of different aspects, but we are, and they come to different conclusions depending on what the particular sector, but we are focused overwhelmingly on getting the best deal for the UK with the EU at the same time as doing the necessary contingency planning for no deal.
Okay. Mr. Robin, did you want to add something? No, fine. Right, moving on. Now, your predecessor promised us in April that he would let us have the results of the Northern Ireland North-South cooperation mapping exercise. It's a very simple question. When are we going to get it?
I need to take a look at that. I don't think we're in a position to give it to you straight away, but hopefully shortly.
I think that's probably what he promised back in April, but we hope it's shortly this time than it was last. Can you tell us, are there any areas of that trade and cross-border activity that would not be covered by the common rulebook on goods and agri-food?
Sorry, if I've understood the question correctly, it's whether there are any aspects of what that would be covered? Of
cross-border activity, because this mapping has covered 130, 140 areas.
I'd need to check, Mr. Chair. I'm sorry.
So you don't, right. Because since then, obviously, you've announced there's going to be a common rulebook on goods and agri-food, and I'm just trying to understand, would that cover all of the areas mapped, or were there some that wouldn't be covered by that?
I think I'd need to check in order to give you an accurate
fine. Well, if you could do that, that'd be very helpful. Now, the government decided in the white paper not to have a common rulebook on services, and we took evidence, as I'm sure you're aware this morning, from the city, broadcasting, insurance and the tech sector, and they told us what they think it will mean. My question to you is, what assessments or studies have been undertaken by the government on the economic impact of that decision not to have a common rulebook? First of all, taking banking and finance. In reaching that decision, did you do any assessment of the economic impact of not having a common rulebook for services on banking and finance? Yes or no is really the question.
I would have to look at the empirical analysis. Obviously, we've taken a whole lot of considerations into account, the direct representations made, the evidence available to us. I would need to check, is the short answer, given the time I've been
so you're not aware that the government has done some economic assessment of the impact of no common rulebook on services on banking and finance?
The analysis of the department, and indeed Whitehall, is ongoing and fluid, as you can imagine, because we're constantly trying to make sure we've got the strongest evidence base. So I would need to check in relation to the bespoke and particular question that he's putting to us. But he will know that from what we said in the white paper, that what we are seeking to do is make sure we've got as much flexibility, both in regulatory terms as possible, as much freedom in terms of international negotiations as possible, and the reason that the distinction is there between services and goods and agriculture is in relation to frictions at the border, which obviously do not apply in relation to services.
Right. So, but you're not aware of anything that has been done in relation to banking and finance, insurance?
Well, the same thing. If you want, if you would like,
I'm just trying to check broadcasting, tech sector, legal profession, accountancy. Did the government look at the economic impact on those
very
important sectors before deciding there wouldn't be a common rule?
I'm certain that the economic impact was considered. The extent to which we commissioned research or direct analysis in each of those different sectors, forgive me, I would want to take that away and check in order that I give you an accurate answer.
But you've just said you're sure it was considered. Did that take paper form, and is that something you can share with the committee? Because I have to say, we received a pretty downbeat assessment from the four people we took evidence from this morning about the potential impact. So if there's something you could share with us, that would be really helpful.
Can I make a gentle suggestion, Mr. Chair? Because obviously there is a very wide brief. I've been imposed a limited time. I'd be very happy if he would like to write to me with all of the particular questions to make sure that I give him a proper and full answer.
No, I'm not. In fairness, because you've only been in the job a short time, the question was about whether the government has done it. You've inherited the job, but clearly consideration was given before you were in post to taking a decision about no common rule. Because back in March, the Prime Minister made it clear we're going to have less access to the service sector, because that's what she said in her Mansion House speech. And the question was, has the government been looking since then at what that will mean for the sectors that cover 80% of the British economy? And that's but I will write to you further.
Please do. And as I've made clear, Mr. Chairman, the judgment that we've made based on the analysis done is that the advantage of retaining regulatory control with the ability and the latitude in relation to free trade agreements is, and whilst having a different approach on agriculture and goods, is the optimum balance economically.
Okay. Now, can I turn to the consequences of no deal? Because you've announced you're stepping up preparation plans for no deal. Indeed, I think you said earlier in the House, failing to plan for no deal would be irresponsible. I think those were your words about 25 minutes ago.
Correct.
Can I begin with the question of EU citizens? Because when I asked you, is the commitment that EU citizens lawfully resident in the UK at the end of December 2020, will they be able to stay? You said there would be no wholesale removal of rights. And I just wonder, on reflection, whether you would like to clarify what exactly you're referring to. Because if there's no wholesale removal, are there some rights that they might lose in the eventuality of there being no deal?
I think, Mr. Chairman, if you check the transcript, but in any event, I'm happy to clarify, I suggested there would be no wholesale removal of EU nationals or removal of their rights. Now, in relation to what we've got in the white paper we've announced today, which was, of course, the subject of the statement, these set out the substantive terms, the mechanism for enforcement, and the independent monitoring authority. Right. I appreciate you're asking me what happens if there is no deal, and I'm making it clear we want to move swiftly to provide legal assurance and clarify the legal position. That will be done through the Home Office legislation, and I think that's probably one for the Home Secretary. But we will make sure there's legislative time for that eventuality.
I understand absolutely what the plan is in the event of there being a deal and the withdrawal agreement's terms relating to citizens being honoured. The question is about what happens if there's no deal. Now, you've clarified, you're referring to no wholesale removal, but wouldn't you accept that would create some anxiety on the part of EU citizens in the UK when, as a new Secretary of State, you're saying we've got to step up our preparations for no deal, and you're saying there'd be no wholesale removal of citizens in the event of there being no deal? I mean, that isn't really providing any reassurance to them about their status, is it?
Well, with respect, Mr. Chairman,
yeah.
I think what does give EU nationals here and UK expats abroad reassurance is the fact that, according to the EU side, 80% of the withdrawal agreement is done. It includes both the substantive protection of rights in relation to nationals. It includes the mechanism for enforcement of those rights in the withdrawal agreement, direct reliance on the withdrawal agreement in UK courts. There is also the Independent Monitoring Authority, and as I set out in the House today, I've given the reassurance in relation to UK expats abroad. I appreciate you want to push me on what happens if there's no deal. We've always, the Prime Minister's position has always been that we will not make unilateral statements or commitments in relation to this subject until we've got the agreement made at the international level. But what I think the reassurance that I'm hopefully giving him is that we would be prepared for that, and the Home Secretary would move swiftly to provide the right legal reassurance and security through relevant legislation.
Right, okay. Can I turn to one or two other aspects of no deal? About 90% of UK dairy exports by volume go to the EU. The EU MFN tariff on dairy is 35.4%. Does your preparation for a no-deal outcome involve any help to the British dairy industry trying to deal with the consequences of that kind of tariff that they could face?
Well, so first of all, what you've highlighted is the folly of any return to the external tariff, I think, on the UK border. And I would entirely agree with that, which is precisely why we should come to a sensible agreement with our European friends and partners.
I get that. The question was whether you have done any planning to help the industry if the deal doesn't come about.
Well, so in relation to the planning we're doing, what I'm not going to do is specific instance by instance is drip feed out the nature of the planning we're doing. But what I can tell you and your committee, Mr. Chair, is that from the legislative side through to the international treaty arrangements, which will of course include the tariff arrangements, through to the infrastructure that we may need in relation to planning for border impacts, right the way through to operational matters, including hiring of border staff, we have a steady stream of work which is looking at all of that. We've got the extra money that has been allocated in the budget, and we will be issuing a series of technical notices, which, forgive me, but will in a, I think, responsible and reassuring way explain what we are doing to mitigate the risks, whilst giving, I think, the full picture, so that whether it's farmers or citizens or other businesses, they understand what their position is and what the support that we'll provide us.
Okay, well, let's take an example of that. The Society of Motor Manufacturers and Traders says that no deal would add £4.5 billion to the industry's overheads. Will one of your technical papers cover the impact on the motor industry and what help you might give them to mitigate that cost?
Well, our technical notices will cover cover a range of different sectors.
Will it cover the motor industry?
I'll need to. It will certainly. It will certainly, in some respects, whether it will be specific and restricted to the motor sector. But again, Mr. Chair, I think what you've done is highlighted what would be a protectionist and regressive step, which would be a return to the EU external tariff. And of course, you'll know, in relation to cars, that the EU has a major surplus with us. So, of course, I think, turning back to your first question, that's a good example of something which would have a disproportionately bad effect on our European friends. We don't want it for them, and we certainly don't want it for UK manufacturers. But I hope he doesn't mind if I headline all the things I'm saying by all the more reason why I'm going out to Brussels on Thursday, striving very hard with our team to get the very best deal.
Okay. Have you assessed what the cost to consumers, British travellers, would be of having to take out travel insurance because the e-hit card would come to an end in that eventuality? Well, have you assessed that at all?
What kind of assessment are you looking for? Because
well, if you've no longer got an e-hit card, you will not be eligible for emergency medical treatment if you fall ill on holiday in Spain or Germany or wherever, and therefore, if you want to cover for the cost of that, you'll have to take out additional travel insurance. The question was whether you've done any assessment of what that will add to the cost of British holidaymakers.
So we've certainly, as part of our white paper and the proposals we're making for continuing sensible mutual arrangements with the EU side, looked at the value of it. Whether we've done it explicitly for no-deal planning already, or whether that's a work in progress, I'd need to check. But again, I'll just say to you, Mr. Chairman, if you pick me up on any one of these different sectors. Sure. What I'm not going to do is drip feed into the public domain little tidbits, even amongst your august committee, because actually what I want to do is set out the technical notices and the planning in a responsible way which informs the public, and so that they can see fully both the measures that we're taking, what they need to do, and the support that they'll be getting.
I wasn't Secretary of State asking for tidbits. I'm trying to explore the state of the government's preparedness for the no-deal outcome, which you'll never hear me say no deal is better than a bad deal, but plenty of government ministers have made that argument. And therefore, if you genuinely think that no deal is better than a bad deal, presumably preparations are being made. Is the government considering stockpiling food?
Again, I will set this out. We will set this out in the technical notices. But I think it would be wrong to describe it as the government doing the stockpiling. What we will make sure, and of course, the idea that we only get food imports into this country from one continent is not appropriate. But we will look at this issue in the round and make sure that there's adequate food supply as well as all of these other things. Again, I'm not going to give more detail until I can set it out in a responsible and full fashion.
That's very helpful. Just very quickly, and before I bring other members in, to you, Mr. Robbins, can you just tell us who you meet on the other side of the table and how often when you're taking part in negotiation? Who's your interlocutor?
So, Chairman, right at the start of this process, we established a system with the EU side whereby each side had a principal and a coordinator. And so the analogy on our side is that the principal is a political figure, now of course the Secretary of State. The coordinator is the official lead for the organisation of the talks and carrying them out. So my normal opposite number is Sabine Wyant, who is the Deputy Chief Negotiator in the Commission.
Fine. But the principle, I mean, there's been a Prime Ministerial statement, which I know colleagues have come on to, saying that the Prime Minister is now the lead negotiator and the Secretary of State is deputising. So has there been a change then? So does that mean the Prime Minister may be negotiating with Michel Barnier now directly?
I doubt it. She has met Mr. Barnier in the past a couple of times. I don't rule it out in the future, but the key interlocutor for Mr. Barnier is the Secretary of State, as his predecessor was. What the Prime Minister means, I think, is what she has meant all along, which is that the overall strategy for and conduct of these negotiations she regards very much as her personal responsibility, now with the Secretary of State very close at hand.
Okay.
And then, would it be helpful if I just gave a slight supplement to that? Because there's been a lot of speculation about this. We're very keen, and Ollie and I have been working very closely together from day one to make sure there is one team, one chain of command, that we get the very best from our brilliant civil servants, and that we've got full assertion of ministerial accountability. And I think that the written statement that the Prime Minister has issued today makes that very clear, so that there can be no doubt about it.
Okay.
There is some changes and some shifting of the Whitehall deck chairs, but the ministerial chain of command and the crucial importance of us working very closely together and having one track is vitally important.
Okay. And then very finally, have any draft text on the political declaration been discussed yet by you, Mr. Robbins, in your opposite number?
No.
No. Very helpful. John Whittingdale.
Thank you, Chairman. Can I ask Mr. Robbins, the proposals which form the basis of the Chequers agreement are a significant departure from the strategy set out by the Prime Minister in her Mansion House speech. Can you tell me, when did you start working on those proposals?
If I may, Mr. Whittingdale, the Prime Minister says that they are not a departure from the principles that she set out at Mansion House. What the Cabinet agreed at Chequers and is reflected in the statement that issued that evening is that this is an evolution of the position that she'd set out at Mansion House and Munich, but consistent with it. So she and her senior ministerial colleagues have been thinking continuously since Mansion House and Munich about how to land those fundamentals in the negotiation that the Secretary of State and I are going to be conducting. And what was agreed at Chequers was a series of further ways in which we could make that case compellingly.
Well, whether it's an evolution or a change, you say that the Prime Minister has been working with her senior ministers on these proposals. Can I put to you the report which said most ministers knew nothing of it until the Monday before Chequers? Even Brexit Department ministers did not see the detail until Thursday. The details were kept from them. Is that correct?
I don't think so, no, Mr. Whittingdale. The Prime Minister met a number of her colleagues over the days and weeks in the run-up to that crucial Cabinet meeting. The propositions contained in the white paper that was published a few days after Chequers drew in many respects on those conversations, including on collective agreements reached long before the Chequers meeting. And I don't think it's a secret to say probably the largest number of meetings she had on the full range of issues was with the Secretary of State's predecessor. So her engagement with colleagues was constant and deep.
So you're saying that the then Secretary of State for Exiting the European Union was fully familiar with the proposals which were then put to the Cabinet at Chequers?
So the Prime Minister and the Secretary of State's meetings must remain between them, but what I am saying is that they saw the issues absolutely in common, and they were working together well on how to try to resolve them.
Because the Secretary of State at the time, his Chief of Staff, has said there was a decision in the Europe unit at number 10, which he run, at the highest level to circumvent the department. The imperative they had was to stop us holding the pen and producing the white paper. You don't accept that?
I don't.
So complaints from DEXU Secretary of State and ministers that this was sprung upon them without any opportunity to influence the proposals which were put to Chequers are just completely wrong. Is that correct?
It's certainly not a picture of the days and weeks leading up to Chequers that I, or more importantly, I think the Prime Minister would recognise.
Well, the Secretary of State himself has suggested that that is the case. And can I now turn to the statement which the Prime Minister has issued today, which says that the Europe unit will have overall responsibility for the preparation and conduct of the negotiations, drawing upon support from DEXU and other departments. Does that not rather suggest that the two of you should swap places? Because in actual fact, you are the Secretary of State in this, and you're being supported by your official sitting next to you.
Mr. Whittingdale, if I may, what we've done is to try and make clear, given some of the tensions that you understandably refer to, and given the mixed functions that both the Cabinet Office Europe team and DEXU were performing, that both as a matter of the official level advice we get, there's one team. That in terms of the ministerial chain of command, there's one team. And that the advice runs coherently and functions as effectively as possible through the ministerial chain of command. And as the statement that the Prime Minister's put out today makes crystal clear, she is in charge of the negotiations. I deputise for her, and we very much welcome the excellent advice we get. These arrangements, as we move into the final phase of the negotiations up until October, are meant to make sure we've got the most effective team. But as I said, one team, one chain of command, and that's the way we'll get the best deal.
But the Prime Minister's statement refers to this as machinery of government changes, and she makes clear that overall responsibility now rests with the Europe unit in the Cabinet Office. Is it not extraordinary that you run the Department for Exiting the European Union, and yet you do not have overall responsibility for the negotiations?
Well, the Prime Minister has the overall ministerial responsibility, and I deputise for her, so I'm the number two. I think, if you look back previously, the Cabinet Office has been performing a range of functions, but then again, so have a range of other Whitehall functions, not least the Treasury. What this does is make it very clear that the different bits of DEXU and the Cabinet Office that were informing and supporting the negotiation are cohere as one team, and that the chain of ministerial command through me to the Prime Minister is very clear.
Well, the chain of command is through you via Mr. Robbins to the Prime Minister, because he has overall responsibility, not you.
So we've been very clear about this, and there's no tension between us, I think that's clear, that all the advice and all the meetings will be attended by me with the Prime Minister as well, with the Prime Minister, and that all the advice will come to me. And that's something actually on all sides we agreed very swiftly. This is the Whitehall machinery of government change to give effect to that.
So both of you would entirely reject the statement by the Chief of Staff of the former Secretary of State that this gives rise to very serious questions about the constitutional propriety of having an unelected unit, almost Nixonian unit, in Downing Street, making policy, making without prejudiced undertakings to Brussels, without real scrutiny and oversight by the Cabinet or the Strategy and Negotiations Subcommittee. All of that, in your view, is simply incorrect.
Well, I wasn't there at the time of Mr. Jackson, who I know very well and hold in very high esteem, but what I'm doing looking forward, and conscious of the tensions expressed previously, is making sure, with the Prime Minister, with Ollie, that we have the most effective and coherent team going forward at this vital moment. I can't comment about what I wasn't here in relation to.
Okay. Right, I think... On this very point, and then I will come to Stephen Crabb. Right, Peter Bone.
I do think that while the Secretary of State clearly can't comment on what happened before, Mr Robbins can. Mr Chairman, it's now widely accepted that there were two texts for the White Paper. One that was drawn up in the Brexit department, which had gone round actually and been circulated to other departments for comment. And there was a secret one being drawn up by Mr Robbins in the Cabinet Office. And then we went to Chequers, and lo and behold, it was Mr Robbins' version that was discussed and agreed to. Now, if that is correct, first of all, is that correct? Did that happen? And on whose authority, Mr Robbins, were you doing that?
So I'm very glad to be able to comment on this, Mr Bone. There was never a second secret white paper.
I said text of.
Sorry?
Text, not a separate white paper. No. I said a separate text which became the white paper.
No, there was not. There were a series of papers produced for the Cabinet in the run-up to Chequers, which was the subject of earlier questioning about the extent to which the Prime Minister had sought to bring colleagues into her view of the situation and the analysis in the run-up. The papers for Cabinet itself, obviously I won't go into the detail of them, but set out the key policy choices. I think the choices were exactly the ones that the previous Secretary of State and other senior ministers saw as the key choices. And then in the days after the Cabinet had reached agreement on the way forward, the White Paper was brought up to date with the agreement reached at Chequers. So it was, if I may say so, a rather standard and classic performance of Cabinet assessing and understanding the evidence, reaching a set of agreements, and then the collective public presentation of that document being taken forward by officials and then cleared by ministers in the usual way.
Mr Chairman, that sounds very plausible, but ties up with what the former Secretary of State has said. He said that there were well drawn up plans, texts if you like, for the White Paper, and he made it quite clear that people would be pleased when they saw that White Paper. It would give them certainty. But that wasn't the White Paper that emerged after Chequers. Are you seriously telling me that you were not separately drafting a text which was presented at Chequers? That it just happened to emerge after they all got together and discussed it? Is that feasible? You wrote a text, didn't you, for the White Paper, which became the White Paper?
So what I and my team did, in concert with a lot of officials across Whitehall, but more than anywhere else from DEXU, is prepare papers for the Cabinet to consider at Chequers. And those papers covered the range of issues. They set out options, they set out recommendations in the usual way. DEXU had been preparing a draft white paper, most of which was not debated implicitly at Chequers because it related to other areas of policy where the government's position was well settled. And in the aftermath of Chequers, that drafting was updated in line with the Cabinet's agreement. That's the position, and there's not much more to be said than that, I don't think, Mr Bone.
So I go from that, Chairman, that there was no separate text that Mr Robbins did, and he didn't have any authority to do so, and then basically it just emerged from the DEXU draft.
The white paper that was published was a white paper prepared by and published by the Department for Exiting the European Union.
And you did not have a separate text that you presented at any time at Chequers?
No, there were papers prepared for Chequers. They were in the end.
What's the difference between papers and text, by the way?
So the distinction I'm making, and I don't mean to sound, the distinction I'm making is that the ministers had before them at Chequers a series of papers that allowed them to debate and explore the issues. Those were not intended as the public presentation of the government's view and the government's position. So then once agreement had been reached on the basis of those papers, then a job needed to be done to translate those into the way in which the government wanted to present its policy.
Presumably, Mr Robbins, the person who decides what papers are presented to Cabinet ultimately is the Prime Minister.
It absolutely is,
right.
Chair.
OK, Stephen Crabb.
Start by asking you, Mr Robbins, how do you view the Chequers agreement, and how do you want it to be received by the people that you meet with when you go across to Brussels? Should it be seen as an opening pitch that broadly gets us onto the right park to begin some kind of sensible negotiation with the Commission? Or should it be seen as a final offer?
I don't know whether you want to comment first.
Yes, I think in fairness, Mr Crabb, that's a political question rather than a technical one. We're very clear that we've come a long way with a principled and pragmatic approach, which I think would be too crude to say meets the EU halfway, but certainly is mindful of the considerations they've got. It gives effect to our commitment to leave the customs union, but maintains borderless, frictionless trade with the EU through the facilitated customs arrangement. It also avoids any return to the hard border. And I think, and the point I've made to our opposite numbers, respectfully, and with goodwill and friendship, is that, and I've said this publicly, we need to see the same kind of energy and substantive engagement in the weeks ahead. And if we get that energy, that flexibility and that pragmatism, we will get a deal in October. So this is not a point of departure. We're far too late down the track for this. This is a serious substantive offer, and we would expect it to be taken that way. And of course, actually, if you look at the way it was received from the EU, there were questions, but it certainly wasn't dismissed out of hand. And that's why Ollie and I will go back out to Brussels, and I'll have an extended conversation, negotiation with Michel Barnier, and that will be, as we enter the last, effectively 3 months of these negotiations, what we'll be working to. Obviously, it's a negotiation, right? It takes two sides, and we need to work with our European partners. But this is not the point of departure.
So let's be a bit clearer, because my interpretation of Michel Barnier's response to the Chequers agreement was that it was opened the gateway to begin a discussion. You're saying that's not how it should be received, that as far as you're concerned, there aren't going to be large substantive changes now to the overall package that Chequers agreed?
Oh no, I don't think we can fetter what the other side does in negotiation. What I'm saying is that we've been looking at various different models all the way along. I've come into this relatively late, as you'll have noticed. But this is, as we've engaged in that dialogue towards the end date of October, a real effort to get us across the line. And obviously there's detail. And I think actually most interestingly were the questions that were asked about how it would work in practice. I think that's quite a good place to be answering questions on the substance, how will it work in practice, rather than going round in circles on theological principles. And I think that's good news for us, and that's what we're going to be taking up this week.
I'd be interested in hearing what persuaded you personally to come out in support of the Chequers agreement. Was it, for example, the economic arguments, because you genuinely believe that what was agreed at Chequers minimises potential negative impacts from leaving the EU, or is it because it really is the only plan in town that stands a chance of getting close to satisfying all of the objectives for Brexit that the Leave campaign made during the referendum and the government has made since, around frictionless borders, leaving the customs union, maintaining an open border in Northern Ireland and so forth?
Well, dare I say it, Mr Crabb, I didn't, when I viewed it, think it was all about me. But what I did think is that it was a principled and pragmatic way to give effect to the referendum, leave the customs union, which I've always argued is crucially important, but bridge the gap with the other side in relation to frictionless trade and, crucially, Northern Ireland in terms of where we get to with the end state. And I suppose more, perhaps beyond that, in instinctive sense, we've got 3 months to go in these negotiations, and I think we should be fighting every minute of every hour of every day, every month, for the best deal we can get. That's why I came out in support.
Sure. You've spoken a lot about pragmatism in the days since taking the job, and that would lead some of us to believe that you will show some flexibility in the negotiations to help get the right deal. Are you able to give us any sense of where you would be willing to see some compromises? So, for example, would you be willing to see a preferential migration scheme for EEA workers if that helps land broadly the Chequers package that you've signed up to?
Well, I think the first thing to say, whenever I've mentioned pragmatism, it has followed the word principle. So we've got a principled and pragmatic plan, and I think it's the balance between the two. I'm not going to drip feed an hour negotiating strategy, and I want to protect the integrity of the negotiating room. I think free movement will end and we will take back control over our immigration policy. The white paper sets out sensible mobility arrangements in relation to businesses wanting to bring their top talent over here, but also other things like tourism and the ability to come to this country and for us to go across the continent with ease. And the ability of students and our youngsters on both sides to take advantage of the educational opportunities and the cultural opportunities on both sides. And all of that stuff's important. And I think it's been made clear that in our approach, and this is as a matter of global policy, international policy, not just the EU, we will say in relation to our close trading partners, there's a sensible conversation to be had about preferential status in relation to visas or the reciprocal immigration arrangements. I think that's the strategic ballpark we're in. I think we also need to make sure that we're not touching on the principal side of things, which is that we've got control over our borders, and in particular the number of people coming here, and also the ability to assert stronger checks, for example, preventive checks at the border.
Okay, Vera Holders.
Thank you. I want to come back to EU citizens' rights and UK citizens' rights in the EU. You've just said about 20 minutes ago that we will get a deal and therefore EU citizens shouldn't worry too much about their future lives in this country. I'm just skimming through, and forgive me if I haven't read the whole thing because it's new. I'm skimming through this new paper which you have, it's your foreword, so I'm sure you know what's in it. It says here, EU citizens living in the UK will be able to broadly continue living their lives as they do now. Could you just say, broadly doesn't mean as they're living it now, it means broadly. Could you just maybe point out what you believe the difference is? What is going to change for them?
Well, so for example, EU free movement will end, but what we've done is we've secured their rights substantively in terms of UK law. That's the proposal. We would then set up the mechanism for those rights to be enforced through the UK courts. We would also set up a separate independent monitoring authority which would be able to take up concerns that they've got, also take up complaints and even take legal action on their behalf. Now obviously in relation to the mechanisms by which we're giving effect to those rights, that's a different set of legal arrangements, but I would expect that for EU citizens here going about their daily business, actually the position will be a smooth transition and they would see no change. But the legal mechanisms and the framework that we're putting in place to provide that is obviously different. I think we need to be honest about that.
Okay. Can I ask a further question about UK citizens then? What are you actually doing to ensure that member states confirm the status of UK nationals living on their territory? Have you talked to individual countries? Because it seems that actually the EU wants to leave quite a lot of these arrangements to bilateral agreements. So have you talked individually to the member states?
So the withdrawal agreement will set out very clearly the legal obligations on all the EU member states. In relation to the Independent Monitoring Authority, the Commission will provide that surveillance role, but you're right to say that actually there'll be a role for each and every member state. And so one of the things that we'll be doing over the summer in the coming months as we engage not just with the Commission and the Monsieur Barnier and his team, but with capitals, is making sure that those preparations and those rights are in place and properly protected. So that is part of the bilateral engagement that we will do with the 27.
And one more thing, because we often hear that negotiation shouldn't be commented on bit by bit, but for the assurance of UK citizens living in member states, will you publish some details that you have negotiated in terms of assurances for those citizens living in the UK? Because we had evidence from quite a lot of them a few months ago, and we felt that they felt very unsure about their future status. So will you, over the summer, publish outcomes that you have negotiated bilaterally?
I will certainly want to make sure we keep the House and this committee updated on the progress, but I think the first thing to say is that the white paper itself, and there's a lot of detail in there, will hopefully provide some of that reassurance. But you're absolutely right to say that as we make progress, we'll want to make sure we update the House as a matter of course, and indeed this committee.
Thank you. Peter Grant.
Thank you. Good afternoon, gentlemen. First question probably for yourself, Mr. Robbins, going back to the Chequers document. Did you seek or obtain any kind of informal assurances from the European Union that that document was likely to be acceptable before it was adopted by the Cabinet?
No, Mr. Grant, not in those terms. I mean, over months now, ministers, the Prime Minister, and of course the official team supporting them have been sounding European partners out on all of the issues that the White Paper touches upon. But it wouldn't, even if we were to try, I suspect, to say, does this package work for you? I doubt we'd get a straight answer. So what we've been trying to do is work out what is in the best interests of the United Kingdom and advise ministers on putting that position forward.
Thank you. And one that probably I think is better taken to yourself, Secretary of State. Your ministerial colleague, the Leader of the House of Commons, has described the Chequers document as a take it or leave it package. Is that how the government sees it? We're going to invite the EU to take it or leave it?
Yes, look, and I think
yes.
Similar to the point made by Mr. Raab. Sorry,
So you said yes. I take it you weren't saying yes.
No, I'm saying yes, acknowledging the importance of the question before I go on to swerve it as best I can. Look, the fact is that we are at a mature stage in these negotiations. This isn't our opening pitch. Of course it's a negotiation. There's no point in saying that we're... And indeed, if you look at the EU's position, their default position, of course that stayed relatively consistent, but of course we talk about all of these issues in the round. But what I would say, this is a far advanced, well thought out, principled and pragmatic document, and we expect to negotiate on the basis of it, and obviously we will consider what Monsieur Barnier and the EU27 come up with. But this is as I said, an ambitious approach which takes into account some of the concerns that the EU has expressed to us, whilst making sure we retain the key equities, both in terms of being faithful to the referendum, making sure we've got frictionless trade with the continent, and also freeing us up to do more of that global international trade we've talked about. So it reconciles, I hope, those ambitions, but it also takes into account our experience of the negotiations to date. So it is a far advanced offer, if I can put it like that.
Thank you. The joint report that the UK and the EU published in December 2017, which is the sort of the basis, the foundation for the ongoing negotiations, included a clear statement that the UK and the EU recognise the position of the Republic of Ireland as a full member state of the EU, as a full member of the single market, a full member of the customs union. Is that something the UK government still absolutely accepts, that nothing will be asked for that would compromise the position of the Republic of Ireland as a member state of the EU?
I would say there is nothing that we are doing, have done or will do which compromises the position of the Republic. They are a close bilateral ally. We respect their membership of the EU. I think the crucial thing as well is mindful of all of the interests and the sensitivities of our European partners, is to be very clear also on one categorical position, which is that we will not allow, for whatever reason, through this negotiation, for the integrity of the United Kingdom to be put at risk. And that is why we cannot accept customs border down the Irish Sea. That is obviously still a sensitive issue, both in terms of the end state, but we have, I hope, through the White Paper set out a very clear set of detailed proposals which resolve those issues, not just in relation to frictionless trade with our continental partners, but also the border with the Republic. And we will continue to talk about the backstop. That's something we agreed to do. But this ought to be the position we set out in the future framework white paper, a good model on which to work towards.
Thank you. The December 2017 report also confirmed that if it wasn't going to be possible for a deal on Ireland and the Republic of Ireland, so Northern Ireland and the Republic of Ireland, to become part of the overall ongoing relationship, that the United Kingdom would, and I quote, propose specific solutions to address the unique circumstances of the island of Ireland. At the moment, all that the United Kingdom has put forward has been a partial solution that is time limited. At what point should we expect to see the UK's permanent proposal for the ongoing relationship between Northern Ireland, the Republic, the rest of the UK and the rest of the European Union?
Well, I think in the white paper on the future relationship, you've got the blueprint for it. I think the issue has been in relation to the time-limited backstop, and again, I understand why you're interested in it as a committee and individually, but I need to, obviously the discussions on that are ongoing, and I need to protect the integrity of the negotiating room in relation to that.
Okay, thank you. Finally, I want to look at the possible preparations or contingency planning for no deal. When will we know if there isn't going to be a deal? Will we know 2 minutes to midnight on the 29th of March? Will we know sometime in October, November of next year? When will the public institutions, businesses, etc. know that we're no longer contingency planning, we're planning for something that is going to happen? How much warning are we likely to get?
Well, it's difficult to judge, not least because on both sides we are committed, and I saw Michel Barnier last week, and we both spoke very frankly about this, and whilst I mindful of not drip-feeding out tidbits from the negotiating room, we're both very committed to the deal. And I'm confident that we can avoid it with ambition, pragmatism and energy on all sides. And for that very reason, because our overriding focus is on getting the best deal, I think it's difficult to say when or how we would get to that point. But what I would say is that we'll be striving throughout the period up until October to make sure that we deliver it. So let's hope this is not an issue that will need to worry us, and I can't give you a precise moment at which it will be clear that there's no deal.
Thank you. A final question. This committee has, I think, on 2 occasions, not unanimously, but by a majority, expressed the view that we found it difficult to imagine any negotiator coming back to offer a deal that was worse than no deal, given that you're now hit, as you say, in Scotland. Are we justified in placing confidence in your negotiating ability and saying that under no circumstances will you come back with a deal that is so bad that no deal is better than it?
Well, I'd be very careful, given my past membership of this committee, to say that unanimous reports are always stronger than split ones. But I hopefully can give reassurance to both sides of the debate, both within this committee, in the House and in the country at large, that I think it's only responsible to prepare for all eventualities, and we're doing that detailed contingency planning. We discussed it in response to the Chair's initial questions. But our overriding focus and energy is about making sure that we are doing everything we can to secure the deal with our EU partners in 3 months' time.
Thank you.
Okay. All right. Thank you very much. Stephen Thames.
Thank you very much, Chair. Does the government intend that UK tariffs and trade policy should be applied at the EU border for goods to be transited through the EU to the UK?
Sorry, Mr. Timms, you speak in such hushed tones. I'm not sure I caught the whole.
I'll speak up. Is it the government's intention now that UK tariffs and trade policy should be applied at the EU border for goods that are intended to be transited through the EU to the UK?
If your question relates to the future relationship and the facilitated customs arrangement, the proposals we set out there are not in relation to the levying of tariffs at the border, but the remittance formula and mechanism that would take place subsequently.
Yes, but the earlier white paper, not the one published today, the earlier white paper says that it is not intended that UK tariffs should be imposed at the EU border. The new clause 36, that the government accepted last week, appears to imply that if the arrangement set out in the white paper is put into effect, it could only be done if other countries were were applying UK tariffs at their border. And it's not quite clear to me what is the government's intention now.
So, first of all, the amendments that were passed recently in relation to the customs legislation, we do not believe are inconsistent with the white paper. The white paper itself, and we can pore over the text, and I'm very happy to do so, envisages the reciprocity that I mentioned in relation not to levying of tariffs at the border. That's not what this is about. This is about the remittance formula and mechanism after the event. And as you'll have seen set out in the white paper, we envisage under the new framework with the common rule book, the FCA and the other arrangements that are put in place, that up to 96% of goods coming into the UK will pay no tariff or the right tariff at the border, and therefore, to put in layperson's terms, I think what this is about is the settling up exercise afterwards and the reciprocal arrangements that we would have with the EU to give effect to that.
Can I just read you what the White Paper said at paragraph 17a? It said the UK is not proposing that the EU applies the UK's tariffs and trade policy at its border for goods intended for the UK. That's on page 17. New clause 36 says, it shall be unlawful for HMRC to account for any duty of customs of a country or territory outside the United Kingdom unless that government will account to HMRC for those duties collected in that country on a reciprocal basis. Now, at least on the face of it, that appears to contradict what the White Paper said.
I don't think so. I think the key is in the word accounting. But if I know his expertise in this area and his background, I'd be very happy to write a letter to the committee outlining precisely what on that point, and also reconciling it with it, because I've had a number of colleagues that have asked this and we've looked very carefully at it. But we do not see any conflict between the amendment that we accepted and the thrust of these proposals. So I hope that gives them some reassurance.
The committee will be very interested to see your letter.
And a diagram, seriously, a diagram with it to explain how this is going to work would be John Hawke.
A diagram?
A diagram, because we're talking about physical things, goods. So how it works.
Very good.
And who pays what money when. It's just a helpful suggestion.
I will see
Mr.
whether
Timms.
we have someone with the artistic
I'm
license.
sure you do. Mr. Timms.
Can I secondly pick up the point that we had an exchange about a few moments ago in the chamber? The new White Paper, which I've had the chance now to have a quick look at, makes the point that the financial settlement is linked to, and I quote, the framework for our future relationship, which will be finalised and published at the same time as the withdrawal agreement. Now, the point I was making in the chamber is that is just a framework. It will just be a framework at that point. It's interesting to see the confirmation that it will be published at the same time as the withdrawal agreement. But as the committee understands it, it won't then be legally binding on either party. It'll be a political declaration. You kindly, in your answer to me earlier, invited me to make any suggestions I might have for what we might do about this. I just wanted to pass on to you the suggestion that Mr. Verhofstadt made to this committee, that if that political declaration was made an annex to the withdrawal agreement, then he told us it would then be legally binding. And I think there may be some difference of view with others about whether that is the case, but at least it would kind of increase the strength, I think, that was perceived of that political declaration and the degree of commitment to it on both parts. And I wonder whether that is something the government is considering.
It's a very interesting suggestion. There are, of course, different ways that can be given effect to the principle of conditionality. One could be incorporating the declaration in the way you described, and therefore it would have a degree of or a measure of legal force. Another would be to make explicit reference in the withdrawal agreement to the political declaration. And although that's not going to transmute it into something that it isn't, it would mean that within the withdrawal agreement some of that conditionality is expressed. But I will take any suggestions from you, Mr. Timms, or the committee in relation to that. But I think I can also give you the reassurance that we're looking at the whole spectrum of options for making sure we give effect to that principle.
Fine. Can I just make one more question, if I may? This is going back to a different point in the earlier White Paper, where it says this at page 92. If there was a challenge to a decision made by an agency that affected the UK, this could be resolved by the Court of Justice of the European Union, noting that this would not involve giving the Court of Justice of the European Union jurisdiction over the UK. It's not quite clear to me what is the distinction that's being drawn there. It's a point that the Prime Minister has made as well, that we want to be members of a number of EU agencies which are subject to the jurisdiction of the CJEU. But it's not clear to me, why does jurisdiction of the Court of Justice over an agency of which we're a member not amount to jurisdiction over the UK? What is the distinction that's being drawn?
So I think the distinction which applies more generally in relation to the White Paper on the future relationship is that the jurisdiction of the CJEU over the UK will be ended. That means that the UK courts will no longer be in a position of referring cases to the CJU involving individuals and businesses. But whether it's on the Common Rule Book or on specific aspects of regulatory engagement where we stay in a participatory role, whatever form that may be, depending on the agency, I think it's common sense that we would need to play by we would need to adhere to the Common Rule Book, or we would need to be adhering to the rules in relation to that agency. But in relation to what we're talking about in relation to the agencies and the Common Rule Book is the ability to get an interpretation of the rule, rather than the jurisdiction that the court would have over a dispute, which means not just understanding what the law is, but then applying it and deciding who wins the case. And so more broadly in relation to the role of the CJU, we've been clear, for example, that the joint committee that will oversee the arrangements for the future relationship would have the ability to refer discrete points for a ruling from the ECJ on a point of law, but that could only be done if both sides agree, so we would have control of that. So it would be like, not quite like an advisory opinion from the International Court of Justice, because it's not, those aren't binding when they come back, but effectively it's a reference for a point of interpretation rather than exercising jurisdiction over the dispute itself. And the other point, I suppose, if you look at the white paper more generally, is the role of international arbitration. So the key difference between that and adjudication is that we have, and both sides have, control over the arbitrators. The law and the process applied is spelt out in the withdrawal agreement, or it could be the future framework relationship agreement, and that any reference would come from the arbitral panel, which would presumably have to agree it, and we would work out the terms of that. But that means for the UK that it is a discrete point of law that is being requested for interpretation. It would be binding when it comes back, but the resolution of the dispute would then be through the UK jurisdiction, the UK courts in the normal way, or the arbitration panel. And I think that gives us the right balance between making sure, as between our cooperation, we have a common set of understandings, and there may well be moments where we want to hold our European partners to principles and rules that they've signed up to, and actually that's important to us. But it allows us to get clarity of common rules for the sake of certainty and the effective functioning of the arrangements we agree with the EU, but retaining jurisdiction in the way I've described, both because the UK courts will decide UK disputes in this country, but also because the arbitration panels will decide the international disputes at the international level. We'll have control over both of those in the way that we've set out in the white paper.
Okay. Now, Joanna Cherry, I think, wants to come in with a short question, but on this very point. Joanna Cherry.
I'm a bit puzzled, Secretary of State, by what you said there. You said, after we leave, the interpretation of the rule will be for the Court of Justice, but applying it and deciding who wins the case will be for the UK court, or what I would call the domestic court. But isn't that exactly what happens at the moment? When a domestic court refers a question to the Court of Justice at present, they refer the question to the Court of Justice for interpretation of the rule. The Court of Justice interprets the rule, gives their ruling, and then the court in England or Scotland still applies it and decides who wins the case. That's what happens at present. The Court of Justice in a reference doesn't decide who wins the case. It makes a ruling on the interpretation. The domestic court decides who wins the case. What's going to change about that?
So the crucial distinction is that it will no longer be courts in the UK referring cases to the CJU, and it will be done by the joint committee, which means that we will have control over that happening. And in relation to arbitration, the arbitral panel will decide the dispute and will also decide on whether or not they wish to refer matters for interpretation to the Court of Justice. So it is a fundamentally different relationship. But we can, I'm sure, discuss this further over the weeks to come.
Okay, Sammy Wilson.
Mr. Robbins, in one of the first meetings that the committee had with your department, I'd raised the issue of the Irish border at that stage, and you'd indicated to us at that stage, although Article 51 had not been signed and there was an imprimatur from the EU that there were no discussions about future arrangements, that the Irish government was cooperating and indeed discussing as far as it could go with the department as to how arrangements could be put in place to ensure that there were no problems along the Irish border. the Irish border has now assumed a role which nobody ever envisaged it would ever have. When did the attitude of the Irish government on this issue change?
So, Mr. Wilson, the Irish government position, I think, to be fair to them, has been consistent in terms of what they want and their objectives for avoiding a hard border, as has the British government's position. In those very early days, some of the positions as to how it was best to try and do that had not hardened, but I suppose over the course of 2016, the Irish government got firmer in their view about the different ways of resolving the border, as indeed the British government firmed up its own view of what was at stake.
So they did harden their view on it, though there seems to be a softening now. Only this week, the Irish Times carried an article, front page article, in which the Irish Taoiseach had indicated that the EU had reassured the government that no physical checks would be needed on the border, even if the UK crashed out of the EU without a deal. Does that not call into question the argument that unless we have a common regulatory area with no internal borders between Northern Ireland and the Irish Republic, there would need to be a hard infrastructure, which is the current EU position, and on which the whole issue of the backstop is predicated?
So I think when the Prime Minister tried to address some of this at the Liaison Committee, Mr. Wilson, what she was saying was, in that situation in which we've unfortunately not been able to achieve a deal, then both sides, of course, will have to reflect on what their responsibilities are and make the appropriate measures and preparations, and that's indeed what the Secretary of State's been talking about in the round about no deal preparation. The Irish government may have a view about what they think they will be able to do or want to do at their border. The European Commission, I'm sure, will have a view. You wouldn't expect me to know necessarily exactly how that will pan out in the future. All I can say is what ministers have said consistently, which is our view that we should avoid a hard border. The Prime Minister said at Mansion House that she was clear that the UK had a role to play in making sure that that came about. And as the Secretary of State said earlier, we remain committed to finding a way through both in the overall architecture of the future relationship to making this debate ultimately unnecessary, but also to keeping to our commitments to find a legally operative backstop in the withdrawal agreement.
Yeah. But I mean, the British government's view at present, and indeed the White Paper and the compromises in the White Paper, are predicated on the EU and the Irish government's insistence that without those kinds of arrangements, there would be a hard border between Northern Ireland and the Irish Republic. Now, we have got the Irish government stating publicly that they have been given an assurance by Michel Barnier and Jean-Claude Juncker that in the event of no deal, no arrangements at all, there would not have to be a physical infrastructure along the border between Northern Ireland and the Irish Republic. That being the case, why have we had to make the kind of compromises which are in the White Paper to facilitate something that the EU say is never going to happen?
So if I may continue, Secretary of State, I mean, I think ministers are very clear that for all the reasons the Secretary of State gave earlier, the package of proposals outlined in the White Paper are about a lot more than trying to resolve the border between Northern Ireland and Ireland. As the Secretary of State said, this is a package that is in the overall interests of the UK and the UK economy, and is driven as much by ministers' concern for maintaining our EU trade in the round, as well as being able to develop the rest of world trade that we hope for in the future. So I don't think it's fair, if I may say so, Mr. Wilson, to characterise the White Paper as all being about solving the Northern Irish border. What the Prime Minister has said is that she remains committed to finding a legally operative way of doing so in the withdrawal agreement. And I think what the Irish government may have said about where the European Union may or may not be on that question in the future, I think that's a debate that if we ever came to it, there would be a strong debate between the two sides as to what was necessary there. The government's objective is to avoid it coming about.
Has that view been tested with the EU? I mean, it's in the public domain. Has that view been tested with the EU? That in the event of no deal, the EU don't believe there's any need for any physical infrastructure along the Northern Ireland border?
It has indeed, and I think we can furnish the committee with the references, but I think the European Commission's spokesperson has been tackled on this issue many times and given the European Commission's view on behalf of the European Council that in the absence of appropriate arrangements, checks and controls would somehow be necessary.
So the EU are telling the UK government one thing while assuring the Irish government something totally different.
So all I'm able to tell you, Mr Wilson, is what I know the European Commission has said publicly on the issue.
Mr Wilson, can I give you the reassurance as we go through these negotiations and as we hear different things which not perhaps entirely consistent with one another from different sides, we will, without wanting to go and brandish them publicly because we've got a negotiation to protect, make the arguments and the points across the board.
Okay. Well, maybe we could have an assurance then, that, because Michel Barnier has been quoted, that unless there is a backstop arrangement, and I don't know if that's a backstop arrangement as determined by the EU, there can be no withdrawal agreement. Can we have an assurance, and are you giving an assurance that if that is the case, that if the EU are insisting on a backstop arrangement, which they don't ever intend to impose themselves if there's no deal, that the UK government will not be signing up, regardless of what threat there is, to a backstop arrangement which impinges on the integrity of the United Kingdom?
Well, we've made clear, and I made clear in the House again earlier, that we'll do nothing that would draw customs border down the Red Sea. And we will, if I, the Irish Sea. Irish Sea.
You can draw as many borders down the Red Sea as you want. I don't really.
Can I also reassure that we have no plans for drawing the border down any other sea either? But actually, I want to protect the integrity of the negotiating room. And one thing that Michel Barnier and I have agreed is the de-dramatisation of these talks. So because there's one thing said on one side, we're focused on negotiation, not drama.
You've given assurance no customs border down the Irish Sea. Can you also give an assurance there will be no regulatory border down the Irish Sea?
We will do everything we can to protect the integrity of the UK, and as ever, Mr Wilson, your point is powerfully made.
Okay. Right, Seema Malhotra.
Thank you, Chair. So just could I ask, the statement that the Prime Minister put out today, were you aware that that statement was coming, and had you seen it before?
Yes, but more importantly than that, on taking up appointment, we had a very sensible conversation about the crossroads of the negotiations we were in, some of the tensions that were widely reported. What do we do to make sure we got the optimum arrangements, one team, one negotiation, clear chain of command, and that would put us in the very best professional position to get the best deal. The work that our civil servants do, whether it's in the Cabinet Office or in DEXU, crucially important. Of course, given the wide range of subjects that are involved in the negotiations, from the withdrawal agreement to the future relationship, the IP, we're drawing on expertise from across the board. What we wanted to make sure in relation to these negotiations over the next 3 months is that we have a single consolidated team in the right place, the right level of ministerial accountability, and think that frankly, the statement codifies what we quickly came to agree on. And to be absolutely clear, the Prime Minister suggested it to me.
Does it, Prime Minister suggested to you, does it seem a little odd to you, though, that a statement is put out downgrading your department 5 minutes before you give evidence to our committee?
Well, it's neither downgrading the department, and frankly, that's, if I may say, it's a caricature.
Widely reported at the moment.
It only came out an hour ago, so it can't be that widely reported. The arrangements
You might be surprised.
From what went before, I can't comment. What these arrangements do, the Cabinet Office and DEXU have always had staff and expertise that have been informing the negotiations. They will now be in one place. They will be supporting the Prime Minister, with me deputising for in the negotiation. I'm already doing it. I was out last week, I'll be out this week. I've offered and will intend to go out right across the summer as regularly as possible. But what we've got is the officials that have been hitherto informing and supporting the negotiation in one place, with the ministerial chain of command very clearly set out.
It's extremely helpful, thank you.
Good.
Could I ask a question about the technical notes that the government is producing that will be setting out the consequences and necessary preparations in the event of no deal? Can I just first ask, just to clarify, are these being produced by the work streams, the 330 plus work streams that are DEXU-led, dealing with the preparation for no deal?
Well, it's a coordination exercise, so of course in relation to the stuff that a specific department will do will rely on their expertise and a lot of the planning preparation, but they're coordinated very carefully with my department, and Chris Heaton-Harris is the junior minister working on that with me. We're very plugged into those departments to make sure not just that in relation to the specific sectoral work that they're doing, that those preparations are as far forward as possible, but also making sure in the round that we've got a coherent picture of the planning and the preparation we're doing.
And how many of I think you had about 70 technical notices that you're expecting to produce, is that correct?
I think it's around that level.
But around 70. And over what time period? Can you just clarify when they'll all be out?
Well, we said over the coming months.
Over the coming months. Okay, so is that August, September, October?
You'll start to see them coming out shortly, but the most important thing is that they're done properly and carefully, given not only the amount of detail that's going in, but the balance between making sure people are getting ready whilst having the reassurance that there's no need to be unduly concerned.
I see. And how many would you say have been completed to date? 70 notices?
I wouldn't be able to put a figure on that, but they're all far advanced.
Okay. And so they're far advanced understanding the impact of no deal and the consequences. At what point do you expect individuals and businesses to start preparing for no deal? And how long do you think it would take?
Well, and by the way, I should say, I think a large proportion of them are far advanced. Others may be a little bit further behind. I want to be clear about this because you asked about the whole 70.
I did indeed.
The initial tranche that I'm looking at are far advanced. So some are more far advanced than others. In relation to, I think that comes back to the question I was asked about earlier.
So just approximately how many would you be looking at? 10? 5?
I wouldn't want to put a figure on it without checking very carefully. But we are in a position, I think, to move reasonably swiftly to publishing them in a series. So that will come, as I said, over the coming months.
So, over the coming months,
yeah.
So we could be having some of the technical notices setting out the consequences and necessary preparations in the event of no deal, potentially, say, after October, November?
I think so they'll inevitably, if we get to October and we don't have a deal, and it's clear that there will be no deal, inevitably there will be further planning and preparation that will take place at that point. So that's inevitable. But what you'll see is from now on, and including over during the remaining summer months, is a series of those technical notices starting to be published.
So that would suggest that you would think companies, businesses, individuals might need to start planning from when? December?
Well, it will depend on the sector and the nature. I mean, we're already having conversations with businesses about both the negotiations, but also about some of those risks. But in terms of, it'll depend on which sector they're in and what the specific nature of their business is, I think, in fairness. Because the agriculture will be different from, say, car manufacturers to services.
So forgive me, Secretary of State, but it almost sounds like you could potentially be publishing these technical notices too late for individuals and businesses to actually start preparing for no deal if no deal is around the corner.
No, we'll be very mindful of the lead time in relation to the technical notices. We're starting to do it relatively soon. They'll be done in a series. Some are more further advanced than others. But what we've made clear is that these technical notices will start coming. They're not the point of departure. A lot of work has already been done on the no-deal planning and preparation. But I think we are entering a different phase of both the negotiations and the planning, where more of it will need to be public-facing. That's partly because of the nature of the operational and logistical changes that we made, partly because, for example, in continuity of our treaty relations, we'll be talking to other governments so people become aware of it. And we want to do it in a responsible, coherent way. But we'll be very mindful of the lead time that businesses and individuals will need in relation to the preparations. And of course, we won't leave the EU until the end of March.
Would that suggest that you would be publishing papers in order of how much longer it might take and how much more risk there might be in preparation for no deal?
Well, that would be part of the consideration, but not the sole one.
Could I ask you just final question, Chair? You previously said that the UK would thrive, in your view, if we leave the EU without a deal. Is that still your view?
Yes.
How
I've always made clear that I
thriving?
think this country has got a huge amount going for it in terms of its economic potential, its cultural soft power, the democratic institutions which we prize, one of the big reasons people voted to leave the EU. I'm absolutely focused, and it goes back to the question I think I was originally asked by Mr. Raab, on getting a deal. That's my overriding prerogative. And I accept that there are risks that need to be mitigated in relation to no deal. But I think this country's best days lie ahead, and I think Brexit over the long term will ensure that's the case. And what I want to make sure is that we continue to pursue this dual strategy of doing everything we can to get the best deal, but being confident enough in ourselves as a country to make sure that we can weather any squall or any of the uncertainty that would accompany no deal.
Do you think we'll be thriving in April next year?
I think, as we've learnt with the forecasts that were made about the state of the UK economy before the referendum, they're either rather difficult and too often proved wrong. But there's no doubt that there will be some risks of leaving the EU that we will need to mitigate. What I'm saying is, to the medium to long term, I'm confident in this country.
And could I just one final question? The DEXU's own internal figures from earlier this year estimated a loss of up to over 10% of GDP in the event of no deal. Have you been presented with those figures by DEXU officials, and has there been any further update on any of that analysis?
We're constantly evaluating and updating our analysis, and also, of course, that will be partly influenced by the ongoing economic data that gets fed through to us, but also the extent to which, as we mitigate the risk of no deal, precisely because we're doing that contingency planning, that we're able to reduce that risk. So the analysis is fluid and ongoing.
And you've asked the specific questions of the economic impact of your team. You've asked to be kept informed of...
I sit on all the relevant committees in relation to the no deal planning, and so we get a whole range of data and wider empirical evidence fed up to us that way. I spend a large amount of my time looking at the papers in relation to all of the impacts of no deal, as well as focusing, as I said, on the negotiations, which are our overriding priority.
Okay. Just on that, your cheerfulness about our future is commendable, Secretary of State, but why do you think it is that just about every bit of economic analysis that's been done about the impact of a no-deal Brexit shows it would be highly damaging to the British economy?
Well, first of all, I could ask the same question about the forecasts that were made about the UK before the referendum vote and what proved right afterwards. I think Kristen Forbes gave an excellent speech when she stepped down from the Bank of England about the frailties of UK economic forecasting. I think there is a bit more humility about some of those forecasts. There is no doubt in my mind that we should be striving for the best deal. In relation to the no-deal scenario, I'm not quite as pessimistic, I think, as perhaps you maybe or some others, not necessarily when I look to the medium and long term. So I don't doubt that we would have to look at the uncertainty that we would face in the short term, but I think long term, actually, we would still be able to thrive. Of course, as with all risks and opportunities, it depends how you mitigate the risks and grasp the opportunities. What I'm not going to do is wallow in pessimism about the state of this country in relation to Brexit. And we're going to go into these negotiations with economic confidence and political ambition. And I'm going to bring to Monsieur Barnier and to the whole enterprise as much energy as I can. What I'm not going to do is allow us to be cower in a corner, afraid of our own shadow, about the potential that that energy and that ambition, that principle and that pragmatism isn't reciprocated on the other side. So I think we'll be braced for all the eventualities.
Well, I hear that. Can I just make a suggestion that you read the transcript of the evidence that we took as a committee this morning from 4 parts of a great British success story: the city, broadcasting, the tech sector, and the insurance sector, and see what those witnesses had to say about what they think the consequences of no deal would be. Jonathan Ginodley.
Thank you, Chairman. Secretary of State, the idea is that at the same time as the withdrawal agreement is signed, we enter into a political agreement on our future relationship with the EU. Hopefully all happening in October. Would that political agreement be legally binding?
I think one way or another, as I've said before, there would need to be a legal requirement in good faith to proceed to negotiate the text of it and to conclude it. So whilst almost by definition the political declaration would provide the framework rather than the full-blown detail of the free trade arrangements and security corporations, I think what there would need to be is a clear requirement on the other side to proceed expeditiously to conclude it. And the whole premise of these negotiations and the whole premise of no deal, of there's only a deal until we do the whole deal, is based upon that.
So just to put that into context, are we talking about the political agreement being, say, 10 pages long and the full agreement several hundred pages long? Would that be a fair sort of...
I'm not sure I could... I mean, if you look at our white paper, it was 100 pages long. Obviously, it's a discursive document. But I would expect that the political declaration would be a substantive document and outlining all the different issues that need to be addressed, backed up, as I said, by the commitment to do that within an expeditious time frame.
I mean, you'll appreciate that there is some concern that we don't really know how detailed that political agreement will be at the current time, as we're getting so close, insofar as, and you may wish to say I'm wrong on this, but my understanding is that the payments that we're going to make are not going to be conditional on the full deal being signed. So in other words, at the time that we sign to the withdrawal agreement and the political agreement, we will in effect be going firm on the 35 to 50 billion, however much it's going to be, and therefore you will understand people are concerned that we'll be giving away all of that money without having a firm future deal. Would that be a fair way of describing it?
It's a fair way of describing the concern. The way I've described the answer is that we will expect, there's no deal until you've got the whole deal, and the whole deal needs to be given effect to. I think your point about the political declaration and what legal casing is put on it, and others, I think Mr Timms had an interesting suggestion around that, are well made. I've been clear that there'll need to be a requirement, whether it's in the withdrawal agreement or a legal requirement, that we proceed expeditiously to this. And of course, once you've got that, you've got an obligation on both sides. And the secret, and I mean, to the extent you're talking about the money, the financial payments and settlement are sequenced. And so it's very clear, I think in my mind, that we would need to be agreeing a deal which is making clear that both sides need to comply with both sets of obligations. And if not, depending on what the nature of the failure to comply with those obligations, then proportionate countermeasures will be taken. But
can I just say that I think that's the first time we've ever heard some degree of conditionality being introduced into the deal. Is that what you're suggesting?
I'm absolutely suggesting that there needs to be conditionality, but I don't think this is going any way further than what the Prime Minister said, or indeed Mr Davis before. But we do need to be clear as we proceed that this is a linked package between the withdrawal agreement and the progress through the political declaration to the future framework, and that needs to be meaningfully set out.
Your predecessor said that it would be possible to negotiate the full trade agreement with the EU before the end of March 2019. Would you agree with that?
By March 2019?
Yes, the full deal.
I think that would be a challenge, but one that I'm up for.
Because I have to say that the EU has since been repeatedly saying that they think that is optimistic in the extreme.
I'm always optimistic.
Yeah, well, I think absolutely in the extreme.
I'm extreme in my moderation.
If we were to get to the end of the implementation period and no final deal had been signed off by that time, so December 2020, is that right? Yes. What would the situation be?
Sorry, can you be explicit about the question?
We get to the end of the implementation period and the final deal has not been agreed.
Oh, I think we need to be very clear that we want to be moving as expeditiously as possible once we've got the withdrawal agreement in place and once that's kicked in order to make sure, I mean, the implementation period is there as a bridge. It's a bridge to the end state, and the future relationship will provide that. So I think we need to be absolutely clear that that is the goal.
Well, the goal, okay, but we've had several, in fact, arguably I think the majority of witnesses that have come here have been saying that it's highly optimistic that we would have a final deal by the end of the implementation period, the average period being 7 years for a trade deal. So that being the case, and I appreciate you will go to get that deal, but what would be the position, what would we do if we didn't have a deal by the end of the implementation period? What are our options?
Well, first of all, I think your first question was whether it was overly optimistic to think we'd get a deal, the contours of the deal settled by March. I think
Correct.
Expecting within a 2-year period is much more reasonable. There are all sorts of ratification procedures for the 27, I appreciate that, but I think it is a reasonable time frame that we should be striving every sinew to stick to.
But what are our options if we don't?
Well, I think that's a very good question. I think we need to be very clear that the future relationship and the details of it are tied down and nailed down within that period. That would be my view.
The previous Secretary of State said that he would be sending hundreds of civil servants to Brussels to negotiate 40 or 50 strands of work. Could you give us an update on how that's going ahead?
Sorry, he would be doing that in the event that...
Well, I think he was saying he was just sort of be getting on with it now. That there were 40 or 50 strands of work, and that hundreds of civil servants would be going to Brussels to negotiate. Could you just tell us what is going on?
Well, I was there last week. I'm going there this week. One of the things we discussed last week, and in fact Michel Barnier mentioned it in his press conference, was the importance of the parallel track that we pursue from now on in the future relationship provisions with us side by side with the outstanding issues on the withdrawal agreement as well as the Northern Ireland issue. So with Ollie and the team and the broader effort across government, we are, and of course through the white paper, we have been injecting extra energy into that, and I will be raising it and discussing it with Monsieur Barnier on Thursday.
Thank you. Thank you.
Now, Pat McFadden wanted to come in on this point.
I'd like to pursue with you, Secretary of State, this question about money and conditionality. You said in the Sunday Telegraph at the weekend that paying the bill would be dependent on the EU fulfilling its side of the bargain, and that, and I quote, certainly it needs to go into the arrangements that we have at international level with our EU partners. The draft agreement, which you referred to in your statement in the Commons a couple of hours ago, am I right in saying that at the moment there is not a conditionality clause in that draft agreement?
Yes, and as I've mentioned, I mean, on the EU zone assessment is about 80% of it is done. So the form for that hasn't yet been agreed.
So it is now UK policy to insert into that document a conditionality clause, which isn't there at the moment, on the financial settlement.
Well, that's, I mean, you read out the quote from the Sunday Telegraph, which was, if I may say, rather carefully calibrated. The point I've made is that the two, we need to go into the arrangements we have at the international level with our EU partners with a clear link between the two. Now, it can be done in different ways. Stephen Timms gave me one suggestion. There are other ways of doing it. Certainly one option would be to insert a clause in the withdrawal agreement, but that could be done in different ways. One of the things I think we need to make sure is, given the comments that have been made, is that there is a clear obligation to move expeditiously to fulfil the terms of the political declaration and get the future partnership deal agreed.
But paragraph 5 of the December joint agreement, which isn't an EU document, it's an EU-UK document, says the Phase 1 agreement is, and I quote, without prejudice to discussions on the framework of the future relationship. You appear to be saying something different now, that the Phase 1 agreement is conditional.
Well, we've always said there's no deal until you do the whole deal. And again, in relation to the white paper that we've put out today on conditionality, I think when he gets a chance, paragraphs 110 and 139 reflect the position that I'm setting out. So I don't think it's new or novel.
If I could ask you, Ollie Robbins, this idea of conditionality on the financial settlement, will you be raising this at your next meeting with Sabine Weyand or your counterparts?
We've been talking about this issue for some time, Mr McFadden, and the paragraph you refer to in the joint report, it's also a paragraph at the end of the joint report that makes clear the government's view that we are, as the Secretary of State has said, negotiating these two documents in parallel. Like the European Council, we believe at the bare minimum that they need to refer to one another. As the white paper said in the few days after Chequers, the government's view is that in the withdrawal agreement there should be a commitment to deliver on the future framework. And what the Secretary of State is saying is that that will be a commitment in the withdrawal agreement. There will be other commitments in the withdrawal agreement, and if one of these commitments is breached, then dispute resolution will need to be put into place that allows us to resolve that dispute. So this is not a new feature of policy. It is something we have discussed with the Commission on many occasions, and dare I say it, I mean, in the way in which the European Council have referred to the linkage between these two documents, there is some basis there for a good conversation.
So we should expect to see, by the end of this process, an agreement between the UK and the EU that the financial settlement that was agreed in principle in the joint December agreement is now conditional on things in the future relationship, and we should expect both sides to agree that.
Well, in fairness, Mr McFadden, that's not what I've said. I was very clear in the language I've used in the Chamber and with the Sunday Telegraph that the two... No, I appreciate that. But the two are viewed as one package, and that failure to fulfil obligations on one or other sides of the bargain would lead to have consequences for the wider deal. Now, that would be either through the dispute resolution process or through proportionate countermeasures, which is the same with any treaty that is signed and concluded under general international law.
Explain how this would work, because we'll be legislating on the bill that you've produced a white paper about today. We'll be legislating for a withdrawal and implementation bill, part of which is the financial settlement. But then, sometime down the line, what you appear to be saying is we will have a right to suspend payments, withdraw payments, claw them back. Can you explain a little bit about how this will work, given that we'll have legislated for the financial settlement as part of the Phase 1 agreement and the withdrawal bill? How would it work sometime down the line when maybe half of it's been paid, for example, in the continuing payments through the transition period up until 2020? Are we looking for some kind of clawback mechanism where we might withdraw some of that?
Oh, I think you make a good point about the sequencing of payments, which will be one aspect of the relationship of discharging our obligations under the agreement. The white paper sets out very clearly the mechanism for payment, including the scrutiny. But the truth is, the point that you're making is not a new one to this treaty or any other, which is that you have a dispute resolution mechanism and you have the general supporting principles of customary international law reflected in the Vienna Convention law of treaties about how you respond if to performance on both sides of the obligations contained in the treaty. The treaty isn't like a contract, but of course it sets the framework for the relationship. So that actually is true of almost every treaty that I've ever been involved in negotiating, whether it's bilateral or multilateral.
But it is new, because we had a minister from your department here a few weeks ago who said to us that this wasn't conditional other than in a good faith way in the future, and that there was no conditionality clause, nor was there a plan for one. So this seems like a new departure to insert legal text into the agreement that there be conditionality on the divorce settlement that we've agreed in principle last December.
Yes, but actually, in relation to good faith is crucially important, and it is an explicit part in the white paper of what will go into the agreement. And of course, I should say at the outset, we're of course catering for every eventuality. I've got every reason to believe our EU partners will go into this with good faith, and once we get a sensible deal that works for both sides, want to implement their side of the bargain the same way as we will be true to ours. But of course, you'll need to have a mechanism for managing the potential creases in the relationship along the way, and making sure, in the same way as any business would go into negotiating a contract, or the UK government goes into negotiating any treaty, of making sure that performance can be properly monitored and there's proper redress in relation to a bargain which is only kept by one side. That's the normal performance of treaty law.
When you have the legal text in this conditionality clause, will you share it with the committee?
Oh, there'll be plenty of time for scrutiny of all of this.
Thank you.
Okay. Just on that point, good faith. How does invoking good faith work if the EU says, well, we think what we're offering you is a good trade deal, and the UK government thinks, well, it isn't a good trade deal? Because I don't see how it can operate if you're trying to apply the kind of conditionality that your interview suggested.
Well, I think that touches on the point raised by Mr. Ginogli earlier, which is that we will need to have a clear enough blueprint in the political declaration that actually what we're really talking about is the technical work of giving effect to something which at the political level is mutually agreed.
So sufficient detail in the political declaration, that's what you're saying?
I think a sufficient sense of direction and the areas that need to be covered and how that will be pursued.
Right. Okay. Richard Gray.
Thank you. You said, and I paraphrase, that the Chequers white paper respects the result of the referendum, preserves the integrity of the UK, and delivers practical reassurance for businesses and citizens. So why is it, do you think, that many former Leave voters have called it a betrayal of the referendum, and what would your message to them be?
Well, forgive me if I don't sort of try and second guess why the different reactions to it. I appreciate the passions and the tensions on all sides. Of course, given the nature of the controversy in this place and amongst the political class, I think it's inevitable that there's a knock-on effect. But I think also it's worth saying that we're at the, not quite the midpoint, but we're at probably the most sensitive point of the negotiations. We're at the point at which we push forward, get the deal, and I think it's far less likely than getting the deal, but that we find ourselves in the worst case scenario of no deal, which we'll manage. So I understand that there's sensitivities around that and there's pressure around that. But what I think people will judge is the package in the round. Whether once we get the detail and the fully fledged withdrawal agreement, when we get the political declaration, it gives a sense of the sunlit uplands to the end state, which respects the outcome of the referendum. And I'm confident that with the white paper, we've got the roadmap to that. But I think I understand why at this point in the negotiations it is tense. And of course, there are strong views on all sides of the debate, whether the people that voted Remain in relation to the customs union and also on the Leave side. I think that's natural.
I wonder if part of the issue isn't the complicated Northern Ireland backstop to keep a frictionless land border in the event of no deal. And Mr. Robbins, I'm looking at the joint statement by the UK and the EU that identified 8 sectors that would need to be tackled. How effective do you think the white paper is in producing effective solutions that the EU can accept to those?
So the areas of cross-border cooperation that are referred to back in the joint report of December and have been referred to since, as members of the committee will know, I'm sure, they cover a range of issues from medical cooperation to agricultural cooperation to energy, not energy, I don't think, and the way in which that cooperation will continue has been something that we've been exploring in the meetings, both with the Commission and with Northern Ireland executive officials and with others with an interest in this. And I think I'm confident that in almost all of the areas that have been identified under that mapping exercise, we will be able to continue North-South cooperation as it stands today. The particular issue that the backstop Mr Wilson was questioning me on earlier comes into play is on the free movement of goods and people across the border between Northern Ireland and Ireland. And there, the White Paper, as Secretary of State said earlier, made a series of propositions that we think are precise and credible for solving that problem in the round for the UK as a whole, rather than specifically needing to solve it only in Northern Ireland and Ireland.
But of course, one of the challenges, Secretary of State, is that when the government produced a partial backstop proposal in June, it did say that it could be given effect through the UK being part of the EU's customs territory. That was one of the options. And to some people, that might look like reverse engineering of the UK into a customs union. What would you say to that?
No, I think we're looking to avoid that. But of course, it is a backstop arrangement, and I think the negotiations are ongoing on this. I'm mindful of its sensitivity. I think the most important thing is there's confidence when we come to the arrangement on it, that there's finality to it. And I think that's one of the key things.
I mean, the White Paper also says, of course, that the Northern Ireland backstop, quote, won't be needed, unquote. Is that because of the government's confidence in reaching a deal?
I think under the normal course of events, we would be confident in the way we've described that we would have the future relationship, and that the proposals we've made, as Ollie has described, would deal with not just the frictionless trade issue, but also specifically the Northern Ireland issue, and therefore if that kicks into effect, we wouldn't need it. But we'd agreed in December to come up with a backstop option, and I think the key thing is that we've come up with an innovative approach which makes sure we deal with the problems, but also that it is time limited.
Yes, but it would be ironic, wouldn't it, for those who find the idea of no deal attractive, if actually no deal resulted in us having to stay in a customs union through the Northern Ireland backstop?
I'm not sure how that would happen, because no deal presumes that we don't sign up to the withdrawal agreement, in which case the backstop wouldn't come into effect.
Right. What about the future of your department? Because some people might argue that once we've left the European Union at the end of March next year, the negotiations that will then happen on the detail of the political declaration and so on could very well be conducted by the team that you already have in the Cabinet Office, with a minister based in the Cabinet Office, and you then wouldn't need a separate department, which in turn would probably save you some of the interrogations here at the Select Committee.
Well, I wouldn't want to avoid the interrogations here at the Select Committee, but of course, ultimately, I think the most important thing is that we've got the right configuration of Whitehall now for these negotiations, and obviously there's discussion about this. I think there will be a need for the coordinating function that DECU does, but frankly, I'm much less interested in the Whitehall deck chairs than in the substance of our negotiating objectives. And if I end up picking myself out of the job, that would be success.
Lastly then, what impact do you think more preparation for no deal will have on investment confidence in the UK? Will it be positive because investors may relish the prospect of preparations for no deal? Or will it be negative because investors will see the likelihood of no deal increasing?
I think it's a very good question, and it's probably a balance. But all I can tell you, Mr. Graham, from the Chequers meeting we had with a whole range of businesses, from manufacturers to financial services, from small businesses to large businesses, that the feedback to me directly, the snippets in the newspapers, the stuff that was said to me overwhelmingly was, we appreciate the challenges of this stage of the negotiations, we welcome the ambition and the pragmatism in your plan, what can we do to help? So I think there was hopefully a sense of can-do and team ethic around that. Now, I can only talk to the businesses that were there, but there were some pretty senior representatives from business and from all sectors, and I think that's important. Certainly it was the first time I've had in large numbers of people saying, what can we do to help? We want to get behind your plan.
And Chair, if I can have one very quick supplementary, very small. And there has been some speculation in the media that actually the Chequers white paper proposals won't allow for free trade agreements that we ourselves negotiated, having brought back trade policy internally. What reassurance can you give to people that actually we will have control of our future trade policy under the Chequers white paper?
Oh, well, the key crucial aspect will be that under the white paper proposals, we'll have the full ability to reduce tariffs across the board on goods, including agricultural goods. And therefore, that is a major incentive in the negotiations with our non-EU partners and indeed in any free trade negotiations. So I understand the concerns that have been expressed around that, but if you look at some of the comments made by Australia, for example, in relation to the Pacific trade deal and various others, and I had a conversation with Ian Fox about this, and we're constantly in touch about this. Obviously, what many international interlocutors want to do is you to have the maximum flexibility. I think we need to be mindful about some of the regulatory changes we would make, whether we're in or outside of the EU. But the key thing that we will have under this model is the ability to have control over tariffs. And that's a major negotiating incentive when we go and talk to some of the growth markets of the future, whether it's Latin America or Asia.
Thank you.
Okay, thank you.
Thank you, Chair, and thank you, gentlemen. You've been very generous with your time. Secretary of State, you've given your full backing to the Chequers agreement, and of course a cornerstone of the Chequers agreement is that we will uphold the rights and protections that we currently enjoy as an EU member state. But you are also on the record as having said, I don't support the Human Rights Act and I don't believe in economic and social rights. You've said it's too difficult to hire and fire in this country. This is a major obstacle to growth. You've said you want to, in your report in 2011, Escaping the Straitjacket, you said you want to abolish the agency workers regulations and to abolish the working time regulations. And you're also on record as having said feminists are amongst the most obnoxious bigots. So is it accurate then to say that you support the piece in the Chequers agreement which says that we want to uphold the rights and protections that we currently enjoy as a member state of the European Union?
Well, can I thank you for the full sort of detailed study you have done of my past
pleasure.
greatest hits.
My pleasure.
In terms of the economic and social rights, the point I was making, and I wrote a book about this in 2009, is that in relation to civil liberties and human rights, actually the approach in this country, the liberal tradition of human rights in this country, along the lines of John Stuart Mill, Locke and Isaiah Berlin, has tended to be to protect civil liberties as human rights, which is a constitutionally superior brand of right, which has Trump status in the courts. Now, in fact, in fairness, and I've been critical of the Human Rights Act in the past, as you rightly say, actually the Human Rights Act takes it as its approach to protect civil liberties, civil and political liberties, and has not tended to include some of the economic and social rights that have been contained in UN conventions. So actually, I think I'm making a straightforward point about human rights. I've never argued that there shouldn't be economic and social rights protected in law. It was about the trump card status given to human rights under the Human Rights Act or any Bill of Rights. On the Working Time Directive, the argument, I mean, the government's been consistent about this, that we're not going to encourage a race to the bottom or diminish workers' rights as a result of Brexit, and I fully support that. And the point I've made about employment and social legislation is that if you're mindful of the pressures that that puts on employers, and at the same time you're striking the right balance with the workers' protections, and both of those things are crucially important, why on earth would you want to abdicate that to the EU and abdicate your democratic control? So actually one of the crucial things that we'll have when we leave the EU is strong standards, bespoke ones that suit the economic and social conditions of this country, and people like you and I, albeit from different parts of the political spectrum, will be accountable to our voters for it. And that ought to be something that we agree on. On the feminism debate, the simple argument I always make is that I think that the value of equality is too important for us to engage in double standards. And I'm fully supportive of all of our equalities legislation. I'm a meritocrat to my core. I don't believe in positive discrimination, which we fortunately have not gone down that path. But I think it is important for you and I who share the value of equality and want to see it applied consistently, that we call out double standards wherever it applies.
Thank you very much. I wanted to move on now to the issue of the Vote Leave campaign, and obviously given that you're now batting for Britain, it's very important that we have full confidence in the authority and integrity of that process, and that does relate to the fact that you were a member of the campaign committee for the Vote Leave campaign. I've got here a copy of the terms of reference of the campaign committee, and it states clearly that one of the roles of the campaign committee will be how Vote Leave interacts with other organisations promoting a leave vote, the way in which fundraising is to be conducted. And it also says clearly the way in which fundraising is to be conducted and donations maximised. So as a member of that committee, which had clear responsibilities as defined in the terms of reference, can you say what you knew about the relationship with Believe, which is of course the subject of the illegal donation from Vote Leave?
Well, I was on the political campaign board, as you rightly say, and I'm proud to have been so. We had no role in relation to the allocation or the disbursement of campaign donations that were made, and so I had no direct personal contact with Believe. I understand the point that you're trying to make, and obviously the Electoral Commission should pursue it in the ordinary course according with the rule of law. I just gently say to you that if what you're really trying to do is discredit the referendum wholesale and push back on it, I think that would create a far greater breach of public trust, and what we all ought to be trying to do, I think your Select Committee has a crucial role, is trying to rally together, forge some consensus of unity of purpose and try and get the best deal.
Secretary of State, I'd gently say to you, I actually think this issue is far bigger than Brexit. I really don't connect it to the referendum. I think it's an issue about the soul of our democracy and whether or not we can restore people's trust in it. What I would like to know, though, is, given the terms of reference of the Campaigns Committee and that you were an active member of the Campaigns Committee, I assume participating in the weekly meetings, had you ever heard of the Believe campaign during your time at Vote Leave?
Oh, I'm sure I was aware of all the other different groups, but that's not what I spent my time focused on, either as a member of that board or as in my wider efforts campaigning.
Yeah, but we know that the donation to Believe was by far Vote Leave's biggest donation, £680,000. It's difficult to believe that the Campaigns Committee, given that it was responsible for making decisions about donations, wasn't aware of the biggest donation.
Oh, well, I think that's an inaccurate description of what that committee did. There was a professional operational team that dealt with the day-to-day running of the campaign and things like the donations coming in. Obviously, we had an outreach function, but what we were primarily focused on was the political campaigning. Oh, by the way, if you want to talk about the soul of our democracy, I don't think second referendum on Brexit would be very good for the soul of our democracy either.
I agree, and that's something I've never advocated. Thank you very much, Chair.
Okay. Craig McKinley.
Thank you very much, Chair. I feel, as you're aware, this is really mainly to Mr. Robbins. This is the Select Committee for exiting the European Union. We have a parliamentary function to fulfil, both to inform Parliament and the public about this process. Now, I feel that over the last few months, I've been misled, because quietly, somewhere, there was a coup d'etat going on between either the proper DEXU department or the Europe department at the Cabinet Office. We've had the previous Secretary of State here outlining the progress he was making, the progress towards a white paper that we expected, and it sounded broadly sensible, and I think it had broad approval from many of us on this committee, and I think it would have had approval by the public at large. But somehow, quietly, that was ripped up. When was that ripped up? And who authorised it, please, Mr. Robbins?
So, Mr. McKinley, I honestly don't recognise the picture you're painting. The previous Secretary of State, with whom I enjoyed working extremely closely and who I spent a lot of time with, and we talked about these issues extensively, and I served him to the best of my ability as Permanent Secretary and continued to work closely with him when I moved to the Cabinet Office. His department worked hard on a white paper which I was very proud to support and to work with as it was published in the days after the Chequers Cabinet meeting. Most of it is traceable back to public interventions that ministers have made over the last few months, and those in turn, of course, are based on collective agreement of the government's objectives and the measures that the government wants to pursue in the negotiation. The Prime Minister approached the Cabinet meeting at Chequers, as I've tried to describe earlier, as is her prerogative, by trying to think through with her colleagues, devoting an awful lot of time to it, what were the right routes through to a successful deal. And part of the format for that, as I think the Acting Cabinet Secretary told the Public Administration Committee the other day, was an opportunity for ministers then collectively to probe, quite informally, some of the analysis and advice that officials, not just me, but others around the system were giving, and for the Prime Minister to set out her view. But in the end, the white paper that the government produced in the days after Chequers was one that was based and grounded fully in that collective agreement reached by the Prime Minister with her colleagues. And it's my job only to support her in steering the committee to the right analysis of the situation we're in and the issues before us in the negotiation, now working very closely with the Secretary of State here, and to make sure that ministers have the best possible information to take those decisions. It's been my privilege to do that for years, and I want to continue.
Okay, well, let's bounce over to the Secretary of State. Welcome to your place, and it's good to see you. My mother always had a very good saying, and that was, to yourself be true. And I'd like to hold to that myself all the time. I've asked many people in the street what do they think of what they read so far about the Chequers Agreement and the White Paper. And they say very clearly, often in quite graphic language, that it doesn't pass their sniff test. Now, I've got no great problem with a common rule book. If you're exporting to the US, you have to apply their rule book. If you're exporting to Australia, you have to apply their rule book, wherever else you want to imagine. The problem I have with this common rule book is that it's not our rule book. If I'm making, I'll use my pen example, I'm making that pen in the UK for the EU, it'll have to comply with EU standards. But if I'm making that to sell it to Mr. Graham just in the UK, it doesn't feel like I can do that. Because if I can't do that, and then Mrs. Cherry in America has got her pen she wants to sell to me that might be just slightly different from the EU standard, but it's acceptable to us, I can't do that deal anymore. My worry is that this common rule book will mean international trade deals are off of the table. We're trying to exempt services from the common rule book because we feel that's where great global trade will be good for Britain, and I perfectly appreciate that. But when you're trying to do that to a country that wants to sell us goods when we want to sell them services, we haven't really got an awful lot to offer. How can you square that circle with me, please, Secretary of State?
Well, I'm not going to tell you that if we didn't have full regulatory autonomy, it wouldn't be an additional string to our bow in free trade negotiations. I think the reassurance I can give you is, first of all, that rulebook has remained relatively stable in recent years. And secondly, the key advantage we'll have in the free trade negotiations is not just the full autonomy in services, but the ability to control our tariffs and bluntly engage in a more liberal approach to free trade in relation to that. So, and that, I think, having conversations I've had with the Department for International Trade, would still mean that we're in a good place to trade more energetically globally with the growth markets of the future. Obviously, on the risk mitigation side, it addresses the issue of friction at the border, and it also, in the same breath, substantially deals with the Northern Ireland question long term. But it's a balanced approach. That's why I said it's a principled and a pragmatic approach.
Do you not think, as part of our future as an independent Britain, we have almost got the saddle of a global duty here? Because for too long, the EU has bullied other countries in trade deal negotiations to accept it their way or no way. I'm very worried that we are going down the same route of accepting it their way or no way, which, I'm thinking about the dreadful unemployment rates in places like Greece, and where the EU is absolutely appalling at getting trade deals together because it insists on its way or no way. I think we have got a global duty to reset WTO rules and say we demand mutual recognition, because this is going to be the key to get global trade really working. And I'm really worried that we're losing what we could be in this world by just saying, yeah, we'll accept it your way and we'll just put up with it.
Well, I certainly share your instincts that we want to be a leader when it comes to global free trade. And if you look at the history of the WTO since the Doha round, it could really do with a shot in the arm from a country coming in with a bit of that ambition and vim and vigour, as I've said in the past. I think what I'd say again, just to repeat what I said earlier, we will have control over our tariffs. That is the major advantage in relation to goods and agriculture that we would have, and also our disposition in the way you've described in relation to our negotiations, whether it's with Mercosur or with the Asian countries. And services is obviously a growth market for us as well. But you're right to say that there's been an element of pragmatism around this, given that we've got different views right across our own party, let alone the House as a whole, let alone the country as a whole.
Can I just finish with you, Mr. Robbins? The Irish backstop, and we now have a multitude of people. We're not going to put a border up. Varadkar, despite his strange protestations last week about aircraft, he's not going to put a border up. And Jean-Claude Juncker at the Dáil recently said he wouldn't be putting a border up either. So, when you're going through the negotiation of where we might end up, so why have we ended up with a backstop that says you almost start back at the beginning? We're almost like in a loop. You know, you get to here, can't have that, well, we'll go to there, can't have that, we'll go back to the beginning again. Who on earth negotiated this sort of backstop, which is Brino in believing in name only? Was it your department at the Cabinet Office, or was this a DEX EU proposal? Which one prevailed on that? Because I do find it hard to believe, knowing the characters that were in DEX EU, that they would have accepted that as the backstop. Because the obvious backstop would be, well, if we can't get there, it's WTO. Who actually was in the driving seat for the Irish backstop as we currently see it?
So if your question, Mr. McKinley, is the negotiation of that text in the joint report back in December, that was a text that the cross-government team worked on. We talked it through with the Commission over several weeks. The Secretary of State was very closely involved in that process, and the Prime Minister, of course, with the Secretary of State, came out and discussed it twice with the President of the European Commission and Mr. Barnier in that crucial week. So it was a process that we entered into on a whole-of-government basis, and with the Secretary of State and the Prime Minister very closely involved. And I should say, I think Secretary of State would, I hope, agree with me. I mean, this was, in many ways, that whole section of the joint report was as much my ministers wanting to give expression to our commitments in respect of Northern Ireland as it was complying with pressure from anybody anywhere else. The Prime Minister, the then Secretary of State for Northern Ireland, since the referendum, have been clear about our own commitments to the border. And in those paragraphs of the joint report, we were willingly signing up to ways in which, chief of which, as the Secretary of State said, must be achieving a good result for the UK and EU relationship in the round, the ways in which we would deliver on those commitments.
Thank you.
Just one question from me. The common rule book, you've made it clear, it's going to cover things that are necessary in order to prevent Pardon? Sorry, I know. Well, wait a second. Sorry, Jacob, you said you were going to come in, but you didn't indicate. But are you indicating now you wish to come in? All right, Jacob.
Yes. Thank you very much, Chairman, and thank you, gentlemen, for being enormously patient, and Secretary of State for coming in so soon after appointment. Mr. Robbins, first of all, congratulations, because you must be very pleased with written ministerial statement number 20 today on changes in the mechanism of government, which move a lot of authority to your department. Where do you see your authority as deriving from?
It's straightforwardly, Mr. Rees-Mogg, I report to the Prime Minister. I work very closely with the Secretary of State, but my authority, as both of ours does, comes from the collective agreement that ministers reached to our mandate in the negotiations, and that's what we are both working to.
And so the general principle that advisers advise and ministers decide is one that it's fair to assume applies, and that the criticisms of you as being the driving force behind policy are unfair because you're carrying out a role on behalf of the people from whom the power comes, and particularly the Prime Minister.
I think that's a very fair characterisation. Thank you.
Thank you. On the relationship between you and the two Secretaries of State, there were a couple of comments made during the evidence today that struck me as interesting in looking at that. One was when you said very early on that now with the Secretary of State close at hand in the negotiations, and the other was when the Secretary of State said that now all the advice will come to me, meaning him. The implication being that the previous Secretary of State had not been close at hand and had not received all the advice. Did David Davis receive all the advice?
So I think what we are both saying is that in the past, at the time for completely natural reasons, Mr. Rees-Mogg, it's not, I don't think this was a bad decision at the time, but there were two teams of civil servants working very closely together, but one advising the Prime Minister, one advising the Secretary of State. Now, as I hope you'd expect, those two teams were the closest working teams you'll find in Whitehall, and they continue to be so. But I think what the Secretary of State was describing, and is certainly our preference for how I want to support him in the job he's got to do, is that it is more efficient and more effective if there is a stream of advice coming to the Prime Minister and the Secretary of State jointly that allows them to take a view on the key issues together.
So it will be a closer relationship than there was with the previous Secretary of State. That's fair from what you've been saying, that the separations will be removed.
I mean, for me personally, I enjoyed a very close relationship with the previous Secretary of State, and we worked together very closely over some very, very important times. And but I hope that the arrangement that has been agreed between the Prime Minister and the Secretary of State for how they're supported over this phase of the negotiations will be, if anything, even more effective.
Okay, and in relation to the Chequers papers, Mr. Whittingdale asked you a question which you very silkily in a very Sir Humphrey-like fashion managed not to answer, which was, when did you start working on the evolution? When did you start working on the evolution?
We have all been concerned for some time, Mr. Rees-Mogg, to deliver the policy that the Prime Minister set out at Mansion House, which was for as frictionless a trade as possible between the UK and the EU, and a series of other objectives for our relationship. Myself, a team from the Treasury, a team from the Business Department, the International Trade Department, we've all been involved in discussions with the Commission, with our other EU partners over the last few months. And so ministers, including ministers in departments, not just the Prime Minister, have been testing us and probing us and challenging us constantly over the last few months as to how are we going to achieve the government's objectives. So in that sense, from the day the Mansion House speech was delivered,
So
we've been thinking very hard about how to make sure we deliver it and how to make sure that the negotiating position we advance with the EU is sufficiently precise to achieve our objectives.
And at what point was this more formalised? Because if we say the evolution began on around the 3rd of March, as I understand it, 120 pages were presented to Cabinet ministers and those attending Cabinet shortly before the meeting of Chequers. When did those papers begin to be written?
So I hope you'll understand if I don't get too much into the weeds of how Cabinet papers are produced. I think there's a pretty long-standing convention about what it's right for me to say about that. It's up to the Prime Minister how she sets the agenda.
Details of what was in them.
Yeah.
I'm asking you for the timeline of when they were written, because this is very important in terms of seeing if Cabinet government is going ahead as one might expect. So the timeline for writing those papers.
So I think the Acting Cabinet Secretary addressed some of these questions with the Public Administration Select Committee a couple of days ago, and what he said then is that it's his role to give assurance on this, that in his view well sufficient time was given to ministers to consider the analysis ahead of Chequers.
I'm not asking about how long they were given, I'm asking about when you started writing these papers.
So, I mean, these papers have their origins in other papers, and we've been producing papers about how to deliver our customs arrangements for quite some time. Maybe I'm misunderstanding your question.
You sit down with pen in hand at some point, or possibly with computer in front of you. I'm probably more pen in hand, or probably more computer in front of you, but if you'll forgive the assumption behind that. Just accusing you of being modern, for which I apologise. When did you start preparing the papers for the Cabinet? An indication of the timeline.
So I think the Prime Minister asked for first drafts of the papers that she was considering at that point putting to the meeting about a fortnight before.
Because the peculiar thing is that the draft white paper that was going on in Dexia seemed to be very different to what was being produced by the Cabinet Office prior to today's statement, written ministerial statement 20 of today's date, changing the mechanics of government. Doesn't that strike you as a little odd?
So, I mean, first of all, if I may, Secretary of State, as I tried to explain earlier in response to Mr. Whittingdale, the white paper that DEXU were working on, and which was then largely published a few days after Chequers, is the product of a long evolution of government policy and development of policy in collective committees, in Cabinet and in speeches over many months. So there was not some sudden twist in the road where one white paper was done away with and a new white paper was written. The way in which the DEXU team had approached that white paper was they were conscious there were some open issues about the way in which we were going to try and get to the precise and ambitious prospectus for our future relationship that the Secretary of State was describing earlier. And what the Prime Minister decided, including in consultation with the then Secretary of State, was that that meeting at Chequers needed to zero in on those open issues.
But the authority to do that hadn't yet been given to the Cabinet Office by this written ministerial statement. This was a responsibility of DEXU. It's only today that that responsibility has been changed.
No, I think the Prime Minister, when she announced the creation of the Europe unit last autumn, she was clear then that we would be an integral part of the Cabinet Secretariat. An important role of the Secretariat is to properly inform Cabinet meetings and to put forward papers when the Prime Minister as Chairman directs us to.
And shouldn't the DEXU department or ex-U department have known that this was going on? And that these papers were about to be provided at the point at which it was writing something else?
I mean, as I tried to explain earlier, and I'm sorry if I wasn't clear, but the closest colleagues I've had in this job have been colleagues at the Department for Exiting the European Union, and they were throughout this process.
But they've said they didn't know. The former Secretary of State has said that he didn't know. So, are you saying that he is misinforming us?
No, I'm not saying that.
No.
I'm telling you what I can tell you about the process, which is that it was a close and collaborative one.
Thank you very much. I think that's extremely helpful. But it is worrying that the authority that changed today hadn't happened then, and that things were going on that the department meant to be in charge of it was unaware of. I attribute no blame to you at all because you are answerable to the Prime Minister. Thank you.
Well, that was a very interesting exchange. I must say, those of us around the table who have been Cabinet Ministers would say that sounds fairly normal to me. And just for the record, Mr. Robbins, you are accountable to the Prime Minister, is that correct? Because
Yes.
you are her Europe advisor.
Yes, I am. Thank you.
And so you take instructions from her?
And from ministers collectively.
Indeed. Now, finally, sorry, and I apologise, Mr. Lefroy.
Thank you very much, Chairman. Firstly, quite a specific question. This morning, in the evidence that was given to us, there was raised the concern about derivatives, and in the event of a no deal, the position of derivatives. And I'm highlighting this. There were many other concerns raised, but because the value of outstanding derivatives dwarfs all other problems in terms of quantity. So it's tens of trillions of dollars were mentioned. Presumably this is very, very high on the list of your concerns in the event of a no deal. I just wondered, Secretary of State, what work you're aware is being done on the legal situation regarding derivatives with our EU, across the EU borders at this time in the event of a no deal.
There's a whole range of work that's being done leveraging all the relevant bits of Whitehall on financial services. In order to address derivatives, I'd need to go back and check specifically because it's such a bespoke and esoteric issue. But again, I think probably the right thing to do, Mr. Ben, is at the end to make sure my private office and your clerks do a list of the shopping list of things you want further information on, and I'm happy to add it to that.
That's a very, very helpful suggestion.
Thank you. I'd be most grateful because in terms of focusing on the things which have the potential of going most wrong, we saw 10 years ago precisely that it was derivatives that probably caused a substantial amount of damage during the financial crisis, and it's really important that is focused on. Thank you. A second point that was raised was concerns over an attempt, perhaps in some areas, to undermine the position of English law as the international gold standard around corporate law and other arrangements. this was raised specifically by our witnesses this morning. Are you aware of that, and what is being done to ensure that our partners in Europe, but also around the world, know that we will defend absolutely to the hilt the primacy of English law in international agreements, and that's not something that we're prepared to allow to slip in any way?
Well, I think that's written into the withdrawal agreement white paper and the future relationship white paper. But I would just say this: are you referring in relation to the due regard obligation to ECJ case law?
No, this was more a more general point that was being made, that this was being used as an opportunity by, shall we say, competitive jurisdictions to say perhaps English law is not going to remain the gold standard.
What I would say is, so of course, the common law has been brilliant at absorbing different influences, partly from the EU, but partly for Commonwealth countries. And what we will do, what we will be restoring, is the ability to do that in a much more autonomous way across the board. And obviously, in relation to services, there'll be full autonomy. We are interlinked into various other jurisdictions through private international law and some of the long-standing private international law regulations, Lugano and others, Brussels regulations that we've got. So there are some where we want to maintain the substance of the framework. But I think the great advantage of the approach that we're taking is that we can retain frictionless trade with the EU, but maintain the autonomy of our case law for all the international transactions you describe. And that's one of the reasons why I think international arbitration as the model for resolving disputes is so attractive, because of course arbitration is different from adjudication in that most arbitral tribunals resolve the facts of a dispute before them rather than seeking to lay down a wider corpus of legally binding precedent, which is what happens when you've got adjudication before the ECJ or indeed some other international tribunals of a supranational nature.
Thank you very much.
John, did you cover the point you wanted to raise earlier? Because you.
I want to put in that point about due regard, if I may, Chair.
Yes, of course, and then. Oh, sorry, I thought you'd finished, John.
No, and
I do apologise.
Just a couple of other things. The government is seeking, understandably, an association agreement. There are other countries with association agreements. Has the government engaged in any dialogue with those countries which have association agreements with the EU, albeit that they will be very different nature, as to how these agreements operate in practice and what can be learnt from, for instance, the Ukrainian agreement or others that are currently in force?
Well, the term association agreement is a term of art. As a matter of international law, the label doesn't really mean a lot other than that you're not just normally covering economic matters. So I think what matters most is the substance, and I think the UK, with its track record and experience in treaty-making relations, has got a huge amount of expertise. But of course, what we will look at very carefully is the if a model is proposed which mirrors one or other that the EU already has, or a different approach that's taken, what's in it for the UK. But I wouldn't get too preoccupied with the form, because it's a malleable legal instrument. It is the substance that matters.
And my final question, which arises partly from some very positive comments you made earlier, is what work is the department and indeed the government doing to show particularly the young people of this country that the future is, as you said, bright, and that it's not a case of certain things which they've seen themselves and their parents having experienced over the last 2 or 3 decades being removed from them?
Well, I think one of the overall approach is not to be blithe about some of the risks in any change of this nature, but to be optimistic and self-confident, because I think regardless of the demographic, that's what people looking to the future want to see. But I would want to point not just to the combination of principle and pragmatism, but some of the specific stuff. So, for example, in relation to mobility, I think the ability, whilst we take back control over our borders and have control of our immigration policy, to make sure that young people can travel across the continent for tourism, for holidays, is going to be important. I think making sure we've got sensible arrangements for enjoying the pan-European cultural and educational opportunities that we've got on both sides of the is crucially important. We're not leaving the EU. We're leaving the EU. We're not leaving Europe. And I think for a lot of people, as we flesh out the parameters of the detail of our negotiating position, as we fill up more of the text of what we've agreed, I think that will become clear. But ultimately, I think this is a period of uncertainty where we need to get to is we can point to the provisions like the mobility provisions to say, actually, those key things that you want will stay, will remain, and we'll retain access to them. And I think that's the key thing. I think for most people in this country, actions speak louder than words.
Thank you, Chairman.
And Joanna Cherry, your last point on...
Yeah, first of all, I should have said congratulations on your appointment, Secretary of State, and thank you for being so generous with your time to us today. I just want to try and understand what's left of the red line on the jurisdiction of the Court of Justice, because recently we passed into law the European Union Withdrawal Act 2018, which said in section 6 that the jurisdiction of the Court of Justice would stop on exit day, which of course is defined as the 29th of March. Now, some of us, including myself, pointed out at the time that that couldn't be right if there was going to be a transition period. And I think your white paper today has finally admitted that's parts of the European Withdrawal Act will have to be repealed because the jurisdiction of the Court of Justice is going to continue throughout the transition period. That's correct, isn't it?
Sorry, is that the question?
Yeah. I want you just to clarify for us that the jurisdiction of the Court of Justice will continue throughout the transition period.
The implementation period. As I set out in the House earlier, yes, it will. And the truth is, even in the passage of the EU withdrawal bill, ministers, including myself, made that clear that what we were doing at the time was legislating for the snapshot of law we were taking from the EU and putting into UK law, and that it would need to be revisited subject to the terms of the negotiations, including specifically the implementation period.
Okay, but Section 6 of the European Union Withdrawal Act says that a court or tribunal is not bound by any principles laid down by the court and can't refer any matter to the European Court on or after exit day, which is defined as the 29th of March. It's quite clear from today's white paper that that will not be the case and that the jurisdiction of the court will last throughout the implementation period. That's correct, isn't it?
So not only is it correct, but we foresaw that when we passed the withdrawal bill.
So why did you pass Section 6 into law if you knew it wasn't going to apply?
We didn't know because it was, as we said at the time, and if you check the Hansard, it's very clear, we said at the time it would the areas of the Withdrawal Act would inevitably be subject to the negotiations that we did. And in terms of the implementation period, it wasn't entirely clear what the... Sorry, can I just finish? Can I just finish answering the question? And of course, we weren't as progressed at that point in relation to the negotiations on the implementation period, and there were various different models that were being bandied around. So it would have been impossible then to have given a cast iron guarantee as to what the outcome would have been, but this was directly flagged by ministers that those provisions would need to be looked at again in light of what we actually negotiated.
You see, I have checked Hansard, and I myself raised this twice with the Solicitor General, once with yourself in your previous role, at a time when we all knew that there was going to be a transition or an implementation period, at which time it was clear that this could never be correct. You didn't admit it at the time.
Well, we did make clear in general terms that we would need to look again subject to the negotiations, and I think even though it was policy to have an implementation period, the content, the nature and the substance of it was far from clear. So, but I appreciate the point that you're making. All I can say to you is that actually the precursor the flag was raised when we had that legislation, perhaps not to the level of specificity that you would have liked, but that was because we didn't know what the substance would be on the implementation period, however foreseeable it may have been that actually we would have needed one.
Okay, well, let's look at what happens when we leave, when we do finally leave at the end of the implementation period, because the Chequers white paper refers to...
Last question, I know you've got to go somewhere. Joanna Cherry.
The Chequers white paper refers to paying due regard to CJEU case law after we leave the European Union, doesn't it? That's paragraph 35 at page 92.
What's the question, Mr. Cherry?
Well, the question's coming. I'm just giving you a moment. I'm referring you to the paragraph out of courtesy, Secretary of State.
Page 35.
I'm referring to paragraph 35 at page 92 of the Chequers White Paper, with which I'm sure you're very familiar, which says that where the UK had agreed to retain a common rule book with the EU, the UK would commit by treaty that its courts would pay due regard to CJ-EU case law.
Yeah.
That's what it says, isn't it?
Yes.
Now, the reason I'm asking you about that is we took evidence from Professor Michael Dugan about what paying due regard means a couple of weeks ago. And he said paying due regard means you have to take into account the decisions of the Court of Justice. Now, of course, as he agreed with me, that's the wording of Section 3 of the Human Rights Act, which you so greatly object to in relation to the Strasbourg jurisprudence. So whereas you've always objected to us taking account of the Strasbourg jurisprudence, you are prepared for us to pay due regard to the Luxembourg jurisprudence in perpetuity in relation to the Common Rule Book. So my question to you is, what remains of the Prime Minister's red line on jurisdiction? Given this duty to pay due regard, and given we know that we're under the jurisdiction of the Court of Justice throughout the transition period.
So there's a string of assumptions which I'm afraid I don't agree with. First of all, I don't agree that due regard and take into account have precisely the same meaning. I think that's been pored over by lawyers and there are different views on it. Secondly, it only applies in relation to the Common Rule Book in relation to manufactured goods and agriculture. The wider approach to the CJEU is very clear that in relation to disputes, there is no automatic jurisdiction of the ECJ, nor is there a direct ECJ jurisdiction over the UK courts in the sense, beyond the sense that you've described, and the UK courts would no longer be referring case to the CJEU. And so in relation to disputes which reach the Joint Committee, which is broadly the political level, they would then determine whether they went to the ECJ for jurisdiction as opposed to it being mandatory, and that would require agreement by both sides. There is also, in relation to the international arbitration, the very narrow ability to refer points in relation to common issues where that's necessary for determination by the ECJ on the legal point, then allowing the arbitration tribunal to decide what that means on the facts of the case. Now, I understand the point you're making, but to describe that as effectively continuity or not a fundamental change in the role of the CJU, I'm afraid I would resist very heavily.
Well, my question was what remains of the Prime Minister's red line.
We will have to, I think, conclude at this point. Can I, on behalf of the whole of the committee, thank you, Secretary of State and you, Mr. Robbins, for being very generous with your time, and you've no doubt enjoyed it so much. Can I just say to you that we look forward to seeing you both again after the October Council, and since I'm sure, Secretary of State, you will have read our 6th report, one of our recommendations was that immediately after any deal is concluded, we will expect to take evidence from you both so we can advise the House before the withdrawal agreement vote. And with those words, can I wish both of you a happy and successful negotiating summer, because we'll be thinking of you wherever we may be. Order, order.
Thank you. Thank you.
The proceeding has ended.